46 of daily list. Kindly adjourn the matter for today and list after puja vacation.
On that topic of the data, the time on the policy. We are waiting for inquiry model. And also the target is matter for inquiry model. For consider the inquiry model.
Let the matter reach. Let the matter reach. Then we'll see. If there is objection, we can't allow.
I beg to mention item number 46 of the daily list.
46.
Service is not complete. After vacation.
Okay, list after vacation awaiting service report. Okay.
Okay.
Button your coat. Button up your coat. No, will not take. Button up your coat. It's not a way to appear before the court. Yes.
Please, your lordship. Item number 7. And from the petitioner side, the standing council is not able to come to this due to personal reasons. The item may be adjourned till 19th, if it's possible.
You're for the petitioner,
Yes.
appellant.
Yes.
Okay, on the prayer of the on behalf of the appellant, the matter stands adjourned today. List after ensuing vacation. Okay.
We have the listing of the case. Transfer petition.
What is the urgency
The date is fixed on 1st of November
for?
for appearance. So, but she is not well to appear in this case.
First is civil court is open.
Yes. Yes.
No,
No.
civil court is not open on first.
First
If
of
it is
November.
opening up for you, I don't know.
1st of November. Well, yes, open.
First of November.
Yes. On the 31st. On the 31st it is open.
On 31st it is open.
Yes.
Okay.
Tomorrow or day? Day after,
No, absolutely not. On that day, I won't even take up any matter.
tomorrow.
Tomorrow.
But I am praying for listing of this matter after vacation on color on 9th.
What do we give it to the court master?
Item number 53, review of a complaint that has been arrived. The mediation number. I have an instruction to withdraw this.
Okay. Okay. Other side is there.
Yes.
Okay.
Respondent.
Mr. B. Kaushik, counsel for the petitioner, and Mr.
P. Kolita.
B. Kalita, counsel for the P. Kalita, counsel for the respondents.
Respondent 1 to 4.
Respondent numbers 1 to 4 are present. Next, it is submitted the bar that in mediation process, the matter has been compromised between the parties, and therefore the learned counsel for the petitioner seeks leave to withdraw this revision on settlement of their disputes outside the court through mediation process. Mr. Prayer is allowed, matter stands dismissed on settlement.
Indicating need of compromise. Need of compromise.
Okay.
Need of compromise.
The deed of compromise, you have to bring it on record. It has been sent by the mediation center. Just get the record. No, then you better have it after vacation. After vacation, because you see, this if it is to be made a compromise, then it has to be brought on record by way of an affidavit.
Or you're not checking. Close it. This has already been referred to the civil court by the VD.
I'll just record the paragraph 4. It is the before that you write. It is also submitted that as per the compromise, deed of compromise and settlement dated 28/9/2023, both the parties were directed to file a joint application in TS 117 of 2019 before the Court of Civil Judge Senior Division, Kamrup Metro Guwahati, for passing a decree on compromise in terms of the settlement. So the it would be open to the parties to comply with the said terms of the agreement. Matter stands dismissed on settlement outside the court through mediation process. Nalage.
Hello. Item 67, sorry. Item 67, sublead.
67. Yes,
It is an interlocutory application for stay of acting. They have prayed for upgrading this matter, but for fixing it.
not two, but I'll take it up. 67. Inform the other side to be here.
Much of it.
Yes. What's the urgency?
Construction over the street line by the street.
I'm not getting you. Please.
The opposite parties are raising construction over the street line. And we wanted to construct the boundary works.
Okay.
I think 14 and 15.
14, 15. Yes.
We're planning this objection petition. So today matter after vacation.
You have informed the other side?
I'm the applicant.
Okay. Who is filed objection?
I am the file. Interlocutory petition they have filed for interim for.
Okay. The learned counsel for the opposite party in IA Civil 983 of 2023 6. Time to file objection in the application. Prayer is allowed. Accordingly, this matter has adjourned today. List after ensuing vacation.
And 992 also. I number 992 of 23.
992 is not on board.
It's there, both the cases. 14 and 15.
Huh?
Yes, it is the 14 and 15.
Oh, it's item
Yes,
15.
yes.
Okay, same in IA 992 of 2023, item 15.
Right.
Okay. Yes, I'm not getting you. Please repeat. For listing, what is the urgency?
Asked by this one, but they have started construction again.
Okay,
Lordship, I like to mention item number 38. This really is there. But for the appellate side, Lordship, the respondent side has not made evidence here. We're making a prayer for adjournment.
okay. On the prayer made by learned counsel for the applicant, matter stands adjourned to the list after ensuing vacation. Yes,
For the correction of orders. Correction of orders, filed by lordship, the case, in that one, the
okay,
was wrongly typed.
okay.
Can we take up the matter?
It may not come today, but it will come tomorrow. Give it.
Please, lordship, I don't think she item number 41. Yeah, that is-
41. You're taking consent of the other side? No ex parte adjournments. Wait for your turn.
Yes, to-
No, I can't help it. Ex parte adjournment, I am not granting. That is all future tense. Who knows about the future? At least I don't know. Ask somebody to be here, make a mention.
May I plead your lordship?
Hmm.
CRP IO 258/23 lordship.
What is the urgency?
For withdrawal lordship.
Withdraw, okay.
For-
Yes, Mr. Roy. Okay,
Permitted to move at the application tomorrow. This dispute is regarding the two rival groups for celebrating Durga Puja. Puja will start now. That is the
okay. Even for puja, there is a fight. Very good.
religious society. There are two rivals
No, it's okay, permitted.
tomorrow.
Yes,
In regard to item 8.
8, yes.
I got, I have converted my client from passive. I'm waiting for the instruction. I've taken the consent of other side also. Let it come after that.
Okay, with consent of the other side, Mr. S. Datta, Senior Counsel, for the appellant, praise for adjournment, praise allowed, list after ensuing vacation. Yes,
Supplementary item 56.
For delivery of order. Item 56.
the application for bail is rejected.
Top of the list, item 1.
Yes,
One thing remains on the last appearance. My lord, the respondent as plaintiff filed a case. The the plaintiff and the plaintiff as you evidence of two witness, AW1 and 2, my lord. And both the witnesses were not examined by the respondent, by the appellant. This is the additional submission.
yes,
Page number 22 of the memo, this clearly.
page
Page 22, 22.
22.
Yes, my lord. The defendant side. Sorry. Top, first paragraph. Okay. The defendant side have failed to cross-examine the PWs even after obtaining opportunity. And hence, the defendant side cannot impeach accuracy, credibility and that paragraph.
Yes,
My friend is a capillary except.
Regarding the cross part matter, even the admitted provision that we did not cross by the physical property. But in fact, regarding the DW code, the appellate matter, itself alludes and he has been cross examined. Here is the question of substantive question of law relating to section 95. Section 90 of the evidence. Although, my lord, the trial court has discussed the evidence and, my lord, pleadings, but the first appellate court, my lord, did not discuss anything regarding the issue of the document, and he is accepted the finding of the trial without giving any reason and an explanation. The finding has been accepted. My lord, in the page number 11 in the appeal memo,
this exhibit B, C, D, and E, what are those documents?
those are the cell lists.
This section.
as regard the titles, minor right title, minor issue number 5. That has not been discussed by the first appellate court.
Pardon me,
Regarding the issue number 5. The first appellate court did not discuss anything. Whatever trial court has held, it was rightly held and decided in favor of the respondent. That is page 11 of the appeal memo. Page 11 in the appeal memo. That is the title issue that must have to be discussed. And why the exhibit has been discarded, that must be some explanation in that regard. There is nothing. Page 11 of the appeal memo. 10 lines from the bottom. It is found that the learned civil judge junior division has disclosed that the issue number 5 is an extensive discussed the issue number 5 and extensive way. The defendant could not impeach the credibility and the plaintiff credibility of the plaintiff side. Thus, on the respondents of the preponderance of evidence. Now it's come to the preponderance of evidence. I find and hold that the learned civil judge junior division has rightly hold and decided the issue on the basis of preponderance of evidence. Nothing has been discussed.
but you'll find several judgments, even I have authored one, where it has been held that if the court is concurring with the finding, then it need not give a elaborate finding.
Now, regarding the issue of the acceptance of the exhibit B, C, D, and E. First, the court held that it was from the proper custody. Regarding the essence of section 90 of the evidence act, first criteria was fulfilled. Now, second part, court discarded without giving any reason. Even the trial court also did not give any reason. Why it has been discarded? When the first part is fulfilled, therefore rejecting the second part, there must be something, Yes, there must be something, regarding the whether the contents or the signatures were not genuine. When the plaintiff denied that those are the fraudulent document, there is no such kind of pleading by the plaintiff that those are the fraudulent document. The signature was fraud, nothing was there.
Please read the trial court judgment at page 21, issue number 5.
Issue number 5. That the issue relating to the factum whether the plaintiff has right title interest over the suit land. The plaintiff admitted that there is a partition among their three brothers, namely such and such on 29th Ahar, 1937 Bengali year. This was 1931. And exhibit 15 is the same Vibhagnama. Accordingly, the three brothers constructed their individual house over their custody land and they started living separately. But the agriculture land, though separated among them, it was cultivated jointly by engaging other people, and crops were divided equally between them. But in the year 1991, when the plaintiff willing to take possession of share of land inherited from the father, the defendant number 10, 11, and 12 gave possession to the plaintiff only the land mentioned in the civil law. The plaintiff denied that his father sold some of his land to other persons for his treatment, and plaintiff father stated that by making conspiracy, the plaintiff father mentioned some of the land was cancelled, a mutation, some of the land cancelled, and also it was about shows that father had transferred of the land. The plaintiff was also corroborated by PW2, who is evidence is stated that the father led Krishna led
Just a moment. What is the genealogy of this of the plaintiffs? Sorry, the defendants, Sirish.
Durganath Sharma was the original Patara, my lord.
Dairam.
Dayanath.
Make something.
You have made a genealogy.
For my.
Dayanath Sharma was the original Patara, my lord. Originally, he had 6 sons, my lord. Some died, my lord.
Okay.
Then
Give us a photocopy after that. After this is over, give me a photocopy.
Taranath, Santinath, and Lakshminath.
No, now this is okay. Genealogy, if I get, it's okay. You give us a photocopy. It would be okay.
The plaintiff also corroborated by the PW rule, who in his affidavit has stated that his father left Corona Medri and some other people used to cultivate in some of the land in late Santiam. Where late Tarakanta and late Lokikanta, PW whose father, used to cultivate in some about 10 bighas of land, and the crop were divided equally among the three brothers. The defendant side had failed to cross-examine PW. And after getting opportunity, hence the defendant side can not impeach the accuracy, credibility, and general value of the evidence given by the chief. And this cannot support this case. The defendant side though filed evidence in affidavit for DW, but the evidence of DW1 expands, and the defendant has failed to bring DW2 for cross-examination. Even after getting.
Just a moment. Who is, what is the name of DW1?
One of the main defendants.
What is the name?
Because their evidence has been discarded, as there has been not been cross-examined.
I'm asking you with reference to this order 41 rule, what do you call? Order 18 rule 3A. The witness, the parties are to be examined first.
Yeah, he's the party. The DW4 is.
That's why I'm asking.
DW4 is himself is the applicant, he's the party.
Okay. All the DWs are defendants.
No, some are independent, but DW4 is the defendant.
DWG is an independent.
DW 1 and 2 are the parties.
Independent. No, one no. DW4 is the defendant, 1 and 2 are the independent. In the that page 23, my lord, that was discussed, my lord. May I read, my lord?
Just a moment. Madan Sharma is not a party. Oh, sorry, Kamala Kanta Sharma.
My lord.
Kamala Kanta Sharma.
Komala already expired, my lord. Was substituted. my lord. No.
On the party.
Pavan Sharma, Girish Sharma are all. non-
Kamala Kanta was the different number one. Sorry, man. Kamala Kanta was the different number one. He is the son of Shantiram.
Son.
Shantiram, Kamala Kanta and Pralupka Sharma, madam. He is the son of Shantiram. So they are integrated as different number 1 and 2. 1 and 2 is the son of Shantiram.
Nandaram Kalita is not a party.
Well, Nandaram, one of the son of their became untraceable.
Nandaram Kalita.
Sorry.
No, Sharma's son can't be
No,
Kalita.
no.
Huh.
Sorry.
Sirish Sharma is not a dependent.
Sirish Sharma, my lord, is the son of dependent of the same man. He is dumped, my lord, dependent of the Ramesh Sharma. So Ramesh Sharma was represented by the Sirish Sharma.
No, he was not a party.
My lord, he was not party, but he represented me. Ramesh Sharma was represented by Sirish Sharma, my lord. In the plain, my lord.
But that's not a disability. It is projected that you are dumb. But he is
My lord, the plain man is mentioned, my lord.
no, it may be mentioned, but it doesn't make him a representative. He is not permitted by law to be represented by others.
It should be Ramesh Sharma. Ramesh Sharma is the different number 10. Ramesh Sharma is the different number 10. And his son are Shishir, Vipul and Rupali.
No.
Sirish.
You see, when it is a minor, under Order 32, we permit them to be represented by our next friend. But is that, or if he's a unsound mind, then also we permit to be represented by others. But is the speech disability is a disability where where it can be represented by our next friend. Because you see, otherwise, Mr. Shiladitya, what I have told you this, when I apply 3A, and if the parties are not in the witness box, then none of your defense would be available.
Yes, yes, number 10, madam. Yes, here is a witness by DW4.
DW4 is a person who has speech disability.
Is the part-
Ramesh Sharma. Ramesh Sharma did not come. Siri Sharma came. Siri Sharma is son of Ramesh Sharma. And this Ramesh Sharma is stated to have speech disability.
And they defend them, they have made party.
Ramesh Sharma was made party.
Huh?
Ramesh Sharma was made dependent, number 10.
No, Ramesh Sharma is defendant. I am not hard of understanding that.
Siri Sharma is not.
Siri Sharma is not a defendant. Siri Sharma is PW4, DW4.
Siri Sharma is the son of Ramesh.
I can't represent my father everywhere. Not in a suit at least.
So he was died during the.
No, he was not substituted. You better check up, because if I apply order
I
Uh,
Siri Sharma.
18
son
rule,
of Siri Ramesh Sharma. It is-
because if I apply rule 3A, then your defense goes.
It was not treated anywhere in the.
That's not required. It's a procedure.
They have made party.
No. You see, you are questioning now the correctness of the judgment, where this has been not been referred, why it has been discarded.
I am the defendant, my lord, they have made party, me as a party member. No, this is the original plea. Where I was made party as.
Who?
Ramesh.
What is the name of your name?
Ramesh.
But Ramesh is not the one who has stood in the evidence witness box. I am reading your evidence. It is in my hand. C1 file is in my hand. The witness who came is Siri Sharma,
Son of Siri Ramesh.
son of Ramesh Sharma. You see, none of the parties stand in the witness box. The probability value of the evidence is lowered. Be prepared, we take it up after vacation. But
This is record file, because I don't-
you take it. It did you.
Responding to teacher.
It is only on one of the submission made by you that we are adjourning the matter. That is, you are trying to say that once the sale deeds were produced for proper custody, then to discard it, some reason must be given.
Yes.
So it is only for that reason we are adjourning it, because if otherwise nobody from the defendant is there in the witness box, then the probability value is not there. We do not even examine it. So only for that reason we are adjourning. On the next date, you please answer that.
Let me check this.
Huh.
After vacation.
After vacation, it goes after vacation. Uh, Mr. Shiladitya, counsel for the appellant, and Mr. P.V. Daslan, counsel for the respondent. On the prayer made by counsel for the appellant, the matter stands adjourned today to enable him to peruse the LCR list after ensuing vacation.
Top of the list, supply item 57.
That was taken up after.
Huh?
I could also please, may be taken up after.
After vacation. Yes, Mr. Agarwal.
He just called me in the morning.
Huh?
He called me in the morning.
Okay.
I said that I will not object, but that was the. What's the expression?
2009 matters. Very difficult to adjourn.
It will be on 7th or 9th.
I'm not fixing a date. I'm just saying after vacation, make a mention if it is not listed. Because all matters are being deferred to after vacation. We won't be able to manage the board.
I'm just worried about not that, not that I will not be able to. Sometimes what happens, I'm going to this station or I'm somewhere else. That is the only difficulty I am. Otherwise, I would have not insisted, why not to fix it.
Okay. Okay, Mr. K. Agarwal, Senior Counsel, assisted by Mr. D. Akram, Counsel for the appellant. This on the prayer made by Mr. M. K. Sharma, Counsel for respondent numbers 1, 2, and 3, matter stands adjourned today. List on 9/11, as agreed to by both sides, list on 9/11/2023.
Okay. Oblige you. I have prepared a chart of the below job.
Okay.
That chart I will.
Daily list, item 2 for motion.
May please also. The wife has filed an application that the husband be directed to meet their child at a public place as per his convenience, the husband's convenience. But the learned court below has rejected the prayer on observation that the husband never voluntarily desires to wants to meet the baby daughter as demanded by the wife due to their matrimonial discord. But in fact, Milord, if your lordship goes to page 40. Paragraph 8, Milord, this is the objection we have filed. That as regards the statement made in paragraph 6 of the application, it is submitted by the present opposite party that he is ready to meet his child at a convenience place. But the opposite party has strong apprehension that the petitioner may get some unruly fee if she found.
Okay. Heard Mr. S. Sahu, Counsel for the petitioner. By filing this application under Article 227 of the Constitution of India, the applicant is.
চাহুজি চালে মোৰ চকুৰে গতি এইখন আজি নাহিল ছাৰ
Yeah.
আৰু তেওঁ কৈছে যে মই অলৰেডি চাইছিলো আপুনি আহক
Oh, acha. As I said, the order dated 31/8/2023 passed by the learned District Judge Sonitpur, Tejpur in Mijje case number 39 of 2022 in TS within bracket M 55 of 2021, thereby rejecting the said interlocutory application. Despite statement of the respondent made in paragraph 8 of the objection. Explanation notice returnable. Give a fixed date after 5 weeks. After 5, returnable on so and so. The petitioner shall take steps for service of notice on the respondent by registered post with AD. list on so and so.
Twenty-nine eleven.
Publish.
Yes,
Supplementary item 58 for motion.
yes, you've got instructions.
Yes, sir.
Pass it on. Show it to her first. Show it to her first and then send over.
I was confirmed today, yesterday. Yesterday I was confirmed from there, that they were already filed another case in.
Then you still want to press this application? You still want to press this application? Okay. But Mrs. MD Medhi, counsel for the petitioners, and Mr. M. Sharma Taned, counsel for the respondents. Next paragraph. Upon instructions, the learned counsel for the petitioner as well as the respondent have submitted that the petitioner has already filed SURFACE application number 91 of 2023 before the Debts Recovery Tribunal, Guwahati. First of all, next part, in that view, the matter. The present application stands closed as the petitioner has availed the appropriate remedy.
I don't know.
Yes, 59. $60.
And part we have had another than the
Does not come.
Finally,
Okay, after some time. 61.
Item 61.
Okay, I'm issuing a notice. Mr. C. Gogoi, counsel for the petitioner. Next paragraph. By filing this application under Article 27 of the Constitution of India, the petitioner has assailed the order dated 18/9/2023, passed by the Principal Judge, Family Court number 3, Kamru Metro, Guwahati, in Mijje case number 45 of 2022. By the said order, the opportunity of the petitioner to file written statement was closed, and the matter is fixed for plaintiff's evidence on the next date. Next paragraph. Issue notice is returnable on. Give a fixed date after 6 weeks. 5 weeks, make it 5 weeks. Returnable so and so. The petitioner shall take steps in course of the day for service of notice on the respondent by registered postal AD. Next paragraph. The learned counsel of the petitioner has prayed for stay of the proceedings. First of, considering the medical documents which are appended to this application. The court is inclined to stay the further proceedings of BJ case number 45 of 2022. No, sorry, what is this? What is the main case? There is a main case, okay. 45 of 2022 till the next date of listing.
29/11, next date.
But take steps in course of the day.
you also had mentioned the opportunity of the petitioner to file.
Achha, petitioner, you are defendant. Petitioner defendant. Okay. But take steps today. Otherwise, on the next date, interim orders will be vacated.
Daily list item 3 for admission.
The matter will be passable for the.
No, this is a appeal. Pardon me? Please speak loudly.
Hardship, my seniors, that's in another.
Acha, you will be coming. Oh, acha, okay. For the time being, okay. At 2, okay. At 2. Item 4. It's a regular first appeal.
This is an appeal against the order dated 19/8/2023 passed by the Ladakh District Judge Kokrajhar in money execution arbitration case number 27 of
19/8/23. Which page?
page number 43. That's the page 44. So what happened in this case, Manoj? There was an arbitration proceeding.
No, just a moment. Against orders passed in execution, you will an appeal lie.
No, I would like to refer to order 21 rule 46 H.
21 rule 46. Ganeshi.
Says that any order under order 46 rule B, C and E. Order 21 rule 46 B refers. to
Just
orders
a
against
moment.
Ganesh.
Just a moment. Which page was the order?
Is 44. Relevant part starts from para 5 and page 45.
Okay, I will show notice.
I have a prayer for.
See, I am not granting. Because till now the order is to hold the amount. You are not prejudiced by that.
Well, in fact, well, for that, the Ladakh executing board was to resort to order 46 rule C. He was required to frame issues as regards the.
No, whatever, till today your money is protected. It's,
My problem is that it's going on work and I'm being asked not to make any payment. Well, And that is where I'm facing the problem, my lord, because the work will be affected. I am a power generating company, and here this respondent number 2 is carrying out many works under me. And if I'm not, if I'm asked to stop all payments, my lord, the entire work will suffer. Because the payments. Well, include
What is
also
the decretal, what is the decretal amount?
in this.
How much amount is to be withheld? Where is the,
Yes, yes, Your Honor. There is a chart, my lord. If your lordship kindly comes to page 53,
52?
53. There is a chart, my lord. The yes, sir. Box row number 3, my lord. Case 27 of the principal amount is 96,158.
So this is 30, 42. 42, 50, 60, 42, 43, 44. About 45 lakh rupees.
Yes.
To that extent, you'll have to maintain.
Also, the person observing that, my lord.
Because you see, the difficulty is the interest part in arbitration. Those are 18% interest. Interest is operating from 2015. 18% interest on the sum rupees 45 lakh would amount to almost nearly 90 lakh rupees.
But the problem is that now we are yet to determine what we will pay to him. Because it's an ongoing contract. He's yet
No,
to
that is
submit
okay.
bills. He's only submitting running bills.
No, that is okay.
So Lordship may observe that to the extent of the decretal amount, the payment will be withdrawn. Other payments may be, I will be allowed to release. my lord.
What according to you is the dues to be paid to them?
My lord, it's yet to be ascertained. my lord. There are many contracts.
Then you give us the details, otherwise we will not permit you like that. A blanket order can't be given without understanding.
Lordship, there's another matter fixed for tomorrow. If your lordship takes up this matter also.
No, we are not postponing it. Tomorrow is again, you have seen the mention.
No,
Tomorrow is another day.
Similar matters, there only the money execution case number is different. If your
But that's okay. Pass orders, we're issuing a notice, as well as notice on the prayer for interim relief. Heard Mr. D. Goswami, counsel for the appellant. So this regular first appeal under section 96 CBC read with order 21 rule 46 capital H CBC is directed against the order dated 19/8/2023 passed by the learned district judge Kokrajhar in money execution within bracket RARB bracket case number 27 of 2015. By the said order, the petitioner, who is availing supplies from the respondent number 1, has been ordered to withhold, not to release any payment due to the respondent number 1 which is found payable to the respondent number 1 on account of execution of any contract work. Full stop. It is submitted that if the payment of contract work is not released, comma, the applicant who is a power generating company would suffer prejudice as the ongoing works will be affected. Expiration notice returnable on, give a fixed date on so and so. The applicant shall take steps within 2 days for service of notice on the respondents by registered post with AD. List on so and so. In the IA, issue a notice. Not so and so, issue notice on this interrogatory application for stay of the operation of the order impugned in the connected appeal. Issue notice to the respondents to show us as to why the operation of the judgment order impugned in the connected appeal should not be stayed and only got modified. Same steps within 2 days, so and so. List on so and so.
24/11.
The next matter, item number 5, only the execution case is different.
This is different, okay. Same,
26 of 2015.
okay, 26 of
2015.
26 of 2015, same,
That
okay. You give us on the next date, the amount due so that we can understand and release it. The difficult part is interest. Yes, 6.
That's the execution part of the agreement. They responded with a plaintiff filed a suit for declaration of right of the common part. Also will find page 19 in the prayer.
Where is the impugn order?
Which one order was it?
Hmm?
Last order.
No, impugn order?
Impugn order was good time. At page 79.
29,
79.
79, okay. You are the judgment debtor.
No. Adjournment.
You are the judgment debtor. Yes,
Also will finally see the title to prayer in title to page 15 also.
15.
15. Please start from 15 and page 17 is the relevant portion. Paragraph 5. Is a partition between the family members of the joint family property. Paragraph 5 also. In the year 2002, defendant number 1, 2, 3, 4 to the hindrance in the park by locking the gate and barred the plaintiff from using the park, creating nuisance which was private and public both in nature. They say I put a lock in the gate because there is a partition of the family property between the whole family members. Now look at prayer portion at page 19. Restrain the defendant court and his men, agents, workmen from putting hindrance of the common part. That is the prayer. Now I'll take your lordship to the decree, page 76.
page
76. It is ordered that the decree that should decree on contest without cause, it is declared that plaintiff has right to use the common part as noted in the schedule. So he has a right, we have no objection to that effect. We have also amicably said that he can use the common part, law could be with both the parties, both the parties will use the law. key in the lock and we use the common road. We have no objection to that effect. After that, Lordship, here the executing court here said we have installed a new gate in the common part and the original gate was removed. And thereafter, we regularly theft has occurred in the compound. We have annexed the affair filed by all the family members, except one person is against us. All the family members is in this suit. Present application. Lordship,
You should, we produce a copy of that, a photograph of the gate.
Lordship,
Let us see the site, how it is there.
what you will find now, Lordship, now they have removed the common gate, installed in the gate. That is why, Lordship, regular theft has occurred in the compound. We want, Lordship, we have no objection to that effect, Lordship. Let the gate be there in the common part till finally decided the matter and both the keys will be both of us.
No, you see from this page 95 onwards, there are a few photographs.
Lordship,
You can't make out anything about the gate.
Lordship, will kindly see, this is, we have annexed one, Lordship, the partition the other drawing, kindly see the drawing.
No, but this photographs at page 95 onwards doesn't show anything.
Lordship, we have annexed the drawing of the partition, which is already annexed, small portion, I have. Lordship, got it?
Yes,
Lordship, the Krishna Kumar Bharatiya is the respondent here, Lordship. His tag number is 643 and 771. Lordship,
yes.
this is the empty road, approach to the empty road, and common road is this, Lordship, last portion. He has entry from the empty road directly. This common road is between us only. These are all the family members, others. Krishna Kumar Bharatiya has the and directly entered from Nalbari. He one enjoying the problem faced by us by removing the gate, which was there from the day one of his grandfather. That gate has been removed at the instance of Krishna Kumar Bharatiya. He is Lordship, this is portion is Krishna Kumar Bharatiya. He is directly to the empty road, he is direct. Only some portion of the land is with the common path. He removed the gate here. That is why, Lordship, there is all day we are suffering because of the theft occurred. That is why we paid for the interim order, Lordship. Record has already come. Record has already come, Lordship. We want that there should be a gate as earlier. Gate is already there, but gate has been removed by receiving. It gate in the compound. Gate be there, we give key to him. We also give the key, he also give the key also. Only for temporary measure, we should be allowed to install the gate also. Temporary measure. He will both the parties. And they may report the police, Nalbari police station, if anything happens. We have annexed the affair. All days, Lordship, theft has occurred in this account because of the gate. And he is enjoying our problem, Lordship. We have annexed the Lordship, the affair filed by us. All the family members are one side, and he is only one side. He is enjoying everything, Lordship, because of this, Lordship. Page 85 is the affair, first affair. Page 56 is the affair. After removing the gate. 84 also affair. 83 is the English version. Because of the removal of the gate, theft occurred regularly. We cannot keep anything also. At the initial stage also, Lordship observed that it will be considered a evidence. We have taken justice service. We have kept Sokidar also. Sokidar cycle also removed. We have kept Sokidar from our at our cost. Sokidar cycle also stored also. Regular theft has occurred.
No, but you see this, come to page 81.
Page 81.
81, it appears that there was an execution and on execution, this gate was removed.
That is why, Lordship, there is no decree for removal of the gate. There is no decree for removal of the gate. As per Lordship is aware, Order 21, Rule 35.
This is something you'll have to agitate there in the trial court. If something was executed beyond the decree.
Because decree was closed, Lordship. If decree execution case was closed. After
No, even if it is closed, you can always ask for the unwinding of that decree which is executed beyond the decree. There's no bar. Even if it is closed on satisfaction. But if something excess of the decree has been executed, the right of the judgment debtor to appear with the execution and ask for a recalling, that's permissible. Because the court has recorded satisfaction. in this revision, we'll have to undo that satisfaction which has been recorded by the court. It will be very difficult.
Cannot say also, order 2235. If a common, the declaration is common portion of the vote. What will be executed? Executed is execution will give a logic the ground meeting and there should be a vote that is to be used for.
No, I am not saying what you're submitting is incorrect. But the problem is in revision. The extent of jurisdiction which can be exercised, that is the issue. So I think it would be better if you make an observation and send you back. So that if the trial court does not hear you, you have a right open to come back.
Okay. You can take the option.
So that will be easier because I will have to assume jurisdiction. There is the difficulty. I'm not saying and for a moment that you are incorrect. Because if there is a theft, no, we understand even in Guwahati, nobody is safe now.
Without lots of gain into the compound. And lots of his share is directly entries to entry lots. We are in problem.
No, you are right. I don't find you're incorrect.
In the petition also, he's not residing in the court of that. He's residing outside, but he's getting problem. He's enjoying their problems. All the family members are in the one side also. All the family members, possible kindly say, all the brothers and the.
No, definitely, gate I understand. Yes, gate is something we understand. But still, we'll close it, give you the opportunity. You have to say anything? It's okay, we are closing this matter. Heard Mr. S.K. Goswami, counsel for the petitioners, and Miss A. Bharali, K. Bharali, counsel for the respondent. Next para. This by this application under Article 227 of the Constitution of India, the petitioners have assailed the order dated 27/4/2023 passed by the Court of Learned Munsif, Civil Judge within bracket Junior Division, bracket close number 1, Nalwari, in title execution case number 5/2023. Full stop. Next, the learned counsel for the petitioners has referred to the pleadings made in the in the suit, as well as the prayer made in the plaint, and the nature of decree passed in the in connection with TS number 3 of 2003.
Which has been subsequently numbered as 66 of 2023.
Sorry, decree dated 17/1/2006, passed in title suit number so and so, which is re-registered and numbered as TS number 17 of 2003, right?
66 of 2020.
60
of 2020.
60 of 2020. Okay. 66 of 2020. Oh, so after remand again a decree, next decree, okay. Decree. Oh, okay. Decree date will change. Decree dated 19/7/2021, passed by the so and so in TS number 66 of 2020, comma previously registered as TS number 3 of 2003. Full stop. It is submitted that the decree was to the effect that the respondent plaintiff had a right to use the common path as noted in the schedule of the plaint. And the petitioners dash defendants, their men, workmen, etc., were restrained from putting hindrance on the common path. First of all, it is submitted that although there was no decree to remove the gate, comma, but in excess of excess of the decree, comma, the gate was removed by the Nazir of the court on 23/5/2023. First of all, it is submitted that after the removal of the gate, comma, the petitioners are suffering theft from their compound, and unwanted people have got a free entry to the compound. First of all, by referring to the rough sketch map of the suit property, so it is submitted that the respondent plaintiff has a separate entrance from the main road. So accordingly, comma, the learned counsel for the petitioner has submitted that by removal of the gate, comma, the petitioners and their family members have been put to a lot of suffering. So it is submitted that the petitioners have been compelled to approach this court because the execution proceeding was closed after the decree was executed on 23/5/2023. Full stop. Next paragraph. The learned counsel for the respondent had prayed for some time as the learned counsel holding the brief was not available. Next paragraph. Having regard to the nature of submissions made by the learned counsel for the petitioner, from it prima facie appears that his submission is based on the nature of decree passed by the learned trial court. And it appears that although there was no decree for removal of the gate, the court is inclined to accept the submissions made by the learned privacy is inclined to accept the submissions made by learned counsel for the petitioners that on 23/5/2023, the decree was executed in excess of the execution was made in excess of the decree. Full stop. Next paragraph. In this regard, the court is of the considered opinion that notwithstanding that the execution petition was closed, comma, if the petitioners have a grievance that the execution was made in excess of the decree, comma, it would be open to the petitioners to move the executing court for passing appropriate orders so as to undo the execution that has been done in excess of the decree. Full stop. Therefore, comma, the court is inclined to grant leave to the petitioners to move the executing court in connection with title execution case number 5 of 2023 with a prayer to restore the execution case to file and to with further liberty to the petitioners to move the learned trial court for appropriate orders. First of all, it is provided that in the event such an application is filed, comma, as the issue relating to So it is, the court is of the considered opinion that the issue relating to execution in excess of the decree is a jurisdictional issue. And therefore, this court would have jurisdiction to direct the learned executing court, i.e. the court of civil judge within bracket junior division number 1 Nalbari, that in the event an application is filed by the petitioners in terms of leave granted by this court, the said learned court shall examine the matter and pass appropriate orders thereon. With the first observation, this revision petition stands closed.
Apologies.
Next para. These are not required. Giving you back your application.
Let me be careful. We have already enclosed the drawing also. Can you just
No, not required because why since I'm sending it back, why
Apologies.
take it back?
Daily list item 9.
Yes. This for announcement,
No, it was dismissed.
appeal was dismissed. Sorry, claim petition was dismissed. Okay, MSC appeal. Claim petition was dismissed. 173. Appeal under 173(1). Of the Motor Vehicles Act, page 1. Notice steps call for the records. Take steps within 2 days. 2 days, we are giving you. Return in 4 weeks.
Item 10.
Two vehicles were involved, like collision. The compensation has been a proportion between the two vehicles. My case is that I had some allegation to evidence. Everything was against the other.
But still the
Even
court,
charge
they,
was against the- actually, the landowner misread the charge sheet of the judge. Charge sheet was against the other vehicle.
where is that?
Yeah,
But still it can be apportioned.
when over the year of the, he did not even claim compensation from it. Allegation was there. Written statement he filed, even evidence clearly stated, and supporting documents also. This- Just because the charge sheet was misread.
Where is the charge sheet?
I have a copy of it. Also.
But you have to bring on record. If I am to read that in appeal, not being a part of memo, I find it difficult to read.
In the
So it was the truck. BR 01GB 0744. That is the offending truck.
Yes, sir.
Your vehicle is
Winger vehicle.
huh?
Winger. Winger vehicle is 8435. He also stated in cross examination that the accident was due to the fault of the truck. That is also hard.
But you'll have to bring it on record. Post it after vacation. In the meantime, you bring it on record. Because for the court to rely on a matter which is not a part of the memo is very difficult. Okay, all sides are really represented. Mr. R. Goswami, learned counsel for the appellant. Case for is granted leave to file an affidavit to bring on record documents which he intends to rely to show that the vehicle insured by the appellant was not the offending vehicle. List after ensuing vacation. Or can we do one more thing? We'll issue a notice, including notice on the prayer for interim relief, and then give you liberty. In the meantime, bring it. No, I understand, but I have to admit this appeal formally. Otherwise, again, there will be a delay.
My name is John Russell, respondent number 1 and 2. Actually, I am not the main counsel. Main counsel is Sharma. He died lordship. So I have it here. It is very difficult.
No, not that. You see, but the problem is that once a lawyer, always a lawyer.
No, I
Who is
have
main,
no-
who is not, we don't know. We don't distinguish.
I have no.
We can't- No, that's okay, but we can't discriminate. The court can't discriminate that. Between a lawyer and lawyer. No.
Otherwise, I have no communication.
No, that can't happen. Once you are there on record, that can't happen. Once you are there on record, that can't happen. We can't issue a notice.
Because I have no there is
No, that's okay, but we can't help it. No. That we can't help. Because once you accept Vakalatnama, it is your burden. They will not take steps. Your Vakalatnama has not been discharged. So even if you may not be holding the brief, but we can't exempt you.
I'm appealing for the response.
Okay. Mr. R. Goswami, counsel for the appellant. We'll give you right now. We'll give you. Mr. Your name is Mr. DK Kalita. Learned counsel for respondent number 1 and 2. I understand. I understand. As Royal Learned counsel for respondent number 3. 6. Who are for others? For others, notice will have to go.
This one, 5 isn't stuck up in.
In the IA. So the Learned counsel for the appellant has submitted that the name of respondent number 5 was struck off in the connected interlocutory application. So accordingly, the name of respondent number 5 is struck off. Next paragraph. MEC appeal 173, Motor Vehicles Act. Judgment number page 1. Please admit for hearing, call for the records. Appellant shall take steps within 2 days for service of notice on the respondent numbers 3 and 4 by registered post with AD. You're appearing. Oh, okay. And Mr. A.M. Khan. Learned Constable for respondent 3 and 4. Okay. Then other steps. The learned constable for the appellant shall provide requisite copies of the memo appeal to the appealing counsel for the respondents. Huh?
I've already provided it.
It's okay. He says that it is not there. You give it to Mr. Kalita.
Already given or just given. Just given.
Oh, achha, no, it's okay. Oh, okay. Don't write that. Okay, don't write that. Issue notice, including notice of the prayer for interim relief. In connection with the connected IA Civil 3003 of 2023. Sir, yeah, okay. Call for the records list after 4 weeks. And in the IA, you write. So issue notice in the prayer for interim relief, returnable in 4 weeks. Post on the prayer made by learned counsel for the appellant is permitted to bring on record by way of an affidavit additional documents on which he intends to rely for the purpose of prayer for interim relief. List after 4 weeks. Liberty to mention is granted.
Item 12,
This actually like the compensation family conditions.
25% you will deposit. Okay. Let me see appeal. Consider. IA. Same notice. The learned counsel for the applicant has submitted that the deceased was a government employee. And he was entitled to compassionate family. What is it called? Compassionate family pension scheme.
CFP.
And the same is required to be deducted from the award. And accordingly, it is submitted that the quantum of the award would be affected. Post of the issue notice. In view of the submission made by the constable of the appellant, the appellant shall deposit 25% of the awarded amount before the registry of the court within a period of 6 weeks. List after 6 weeks. State enforcement is state, subject to deposit of expense. At many cases, IA. This was one. Item 13.
This is the pillion rider under act liability. And in the act liability, there is a Supreme Court that says the pillion rider in an act policy. Distinguished from the package policy, comprehensive policy.
Should not be entitled to. Okay, appeal admitted, call for the records. Page number 1. Stay application. Notice. The learned counsel for the applicant has submitted that the deceased was a pillion rider in a motorcycle. Motorcycle, which was insured under the which was insured under the Act policy, and it is submitted. There are judicial pronouncements to wherein it has been laid down that a pillion rider who has died in a road accident involving act policy, vehicle having act policy, and is a pillion rider, would not be entitled to compensation. Just accordingly, the enforcement of the impugned award dated so and so is stayed without requiring the appellant to make any pre-deposit as a condition for grant of stay. List after 4 weeks.
Supply item 62.
Please read your lordship. Lordship has seen that the petition is quite bulky. And I do not like to trouble this honorable court today on the eve of the vacation. So if the other side agrees, there are certain issues which are before the arbitration, not before the arbitral panel, before the additional district judge courts, number 2 lordship. Wherein the impugned order was issued on 3rd of October 2023, lordship will find it at 404. So there are allegations, counter allegations of various defaults on the part of either the contractor or the employer. So according to us, lordship, they have failed and they could not proceed with the work. The work relates to lordship, the 4-laning work of Jorhat to Jhansi, about 38 kilometers. This bears a lot of huge public interest, this work. Lordship knows after Jorhat how the road is. So this is one of the litigation relating to that part of the highway construction. In this case, the application under section 9 of the Arbitration Act, the Honorable Court was pleased to note all the defaults on the part of the employer. And finally, the order was passed. Lordship will find that order at 421, the operative part. Last paragraph. Having regard to the facts and circumstances narrated above, I am of the considered view that balance of convenience at this stage found to be in favor of applicants for passing the interim relief. Since applicants have raised some disputes by way of filing this petition, it appears to me that an order for granting interim relief at this stage in favor of the applicant should be passed till a decision can be taken on hearing both the parties. Accordingly, it is ordered that respondents shall not resort to any consequential action against the applicants in pursuance of the termination notice dated 29/9/2023. It should have been 22 now.
No,
It is corrected copy lordship till the next date. So the order is that there should not be any coercive action against them. My concern is lordship regarding this, I have no quarrel at this stage. Let them file affidavit, whatever allegations are there, counter allegations, lordship, both the parties can file their, complete their pleadings. Only thing is that after this termination order, the state of NHIDCL at paragraphs 17, 18, lordship will kindly come to page 19.
Page 19.
Page 19. Paragraph 17. Prior to issuance of the aforesaid interim order dated 3/10/2023, the project work in question was divided into 4 packages by the competent authority for smooth functioning of the work in a time-bound manner, and it was decided by the applicant to go ahead with the NIT individually for the aforesaid packages, and as on that, the bidding process is at final stage of award. So this is the position. Initially, lordship, they wanted to foreclose the project. Then they also issued 2 notices to terminate the contract from their side. We rejected their plea and we further went ahead and we give them the curing period, during which period they could not comply with the requirements of the amount of work to be done during the curing period of 60 days. Now, thereafter, we finally issued a termination notice and termination order, lordship. So after that, lordship, in fact, they are not interested to continue with the work. And we are also not wanting them to continue. And instead, we have bifurcated the whole package into 4 components, and the process for tendering is going on when we are reaching at the final stage of award. The work should go on. If lordship is pleased to clarify the learned additional district judge order, that it is in respect of any coercive action against the petitioner, nothing to do with the ongoing tender process. So that is the clarification I am seeking at this stage. let them file affidavit, Lordship, then Lordship may be
But
pleased
to
to
that
take up the matter.
extent, my lord, I have no objection because it was never my case before the learned court, before the district judge, that to stop the ongoing project or anything. We were only concerned about us because what has happened, we had issued the termination. Pursuant to our termination, they issued a termination. Now, the moment they do that, certain adverse consequences comes where they can resort to. That is why it was necessary for us to move an application under Section 9 before the learned court, learned district and session judge. But your lordship knows that before moving, we can do that. In fact, we have already filed a letter before the authorities for mutually settlement as per the arbitration clause. Now, at that time, the court below have said no consequential actions against us. This is very clear. However, since the authorities are understanding it in a different way, your lordship may clarify it that they can complete the subject work engaging any other person they want to. That because I am not on that. I'm only concerned for myself. And the next date is fixed on 30th. Then whatever objections they have, they should file it there. Let the court decide whether. This is my humble submissions before your lordships, because the court is competent there. Otherwise, there's nothing. Their main concern is this.
You're
Because
sitting
as
so seriously. I thought that my 1 o'clock is gone.
That is why my opening statement was that I do not want to trouble this one. Even I have
No,
to read
because
through
I
the
think
whole
it's a
paper to
misunderstanding.
come to this conclusion.
It's a
That
misunderstanding.
actually the core issue is very small.
Yes, because in fact.
But then in fact, appeal was not even required then.
Not required, not required.
You could have moved the,
On 30th, it could have been, they could have filed their objection, whatever on merits. Because this, in fact, the learned court had asked me this question that you have already given a termination. You are not interested. I said, no, I'm not interested. Because I could not complete, therefore, as per the contractual terms, I had given a termination. So they can complete it with whosoever they desire to.
The
No
only
issue.
thing is that they are removing some of the machineries that they
So
have
those
substantially
contractual
they have done.
obligations Come in as it is mentioned. That is a different thing.
I'm just making submission. I'm not bringing anything on that.
All
aspect.
that is a different aspect.
So if Lordship is pleased to clarify, then this matter may be disposed of today itself.
Absolutely, because next date is fixed on 30th for objection.
okay. On 30
October, this 30th.
October, it is, civil court is open.
It's open.
Okay.
First day of reopening, I'm told after the check.
Okay.
So there you go.
Heard Mr. D. Saigyak, Senior Counsel, assisted by Mr. R. K. Borpujari, Counsel for the, Mr. R. Borpujari, Counsel for the appellant. As well as Mr. K. Goswami, and a Senior Counsel, assisted by Mr. B.D. Deka, Counsel for the respondent.
Lordship, my learned friends name is very important.
Okay, and Mr. R. P. Talukdar. Okay, and Mr. P. Agarwal, and Counsel appearing for respondent number 4. So you will be for 1, 2, and 3, Mr. Deka? Mr. Deka, 1, 2, and 3. Then who is 3?
The bank was a former respondent. They may have made them.
No, this is team leader.
Oh, that is the authority engineer.
Yes, authority.
That's wrongly mentioned as 3. That should be, that is your lordship knows under these kind of contract, there is an authority engineer. So that is number.
No, my difficulty is different. Once is a party and I can't dispose of without a notice.
Then pro forma response. Then in that case, Lordship may be pleased to
There's
issue
nothing
notice.
against them.
Let the notice be
There's
issued.
nothing against them.
No.
No, no.
Anyway,
But to dispose of an
Technically,
appeal,
correct, Lordship, is
is
hard.
dispose of an appeal
Let the
without
notice be issued.
hearing.
Lordship will only clarify
yes.
that we can proceed with the ongoing tender process.
Yes. yes,
Okay.
yes.
Let the notice be issued, Lordship.
Agreed by the order dated 3/10/2023 passed by the learned additional district judge number 2, Kamrup Metro Guwahati in Miss within bracket ARB bracket close case number 55 of 2023. The present appeal has been filed under section 37 within bracket 1 within bracket small b of the Arbitration and Conciliation Act. You should notice returnable. You can get them appeared
Yes.
after reopening.
Yes.
On Seventeen 11/2023, the applicant shall take steps for service of notice on respondent, proforma respondent number 3 by registered post with AD. Or we make it Dusty.
We'll take the still option. The still.
Okay.
Permit us, and we'll file a.
Takes a step for service of notice on respondent number 3 by way of Dusty. By routing the process to the registry of court, and upon service, an affidavit of service shall be filed prior to the next date of listing. Next para. The learned senior counsel for the appellants has prayed for a clarificatory order from this appellate court. Mr. It is submitted that while terminating the contract work awarded to the respondent number 1 by termination notice dated 29/9/2023, it should be 22.
29. They have corrected it. In fact, initially the prayer is 22.
22 is my termination order and 29 is their termination order. That is why. the
29/9/23.
Yes.
Okay, 29 and 23.
Immediately in 2 days, we moved the
Okay,
application.
okay. 23. Comma, the appellants have taken steps for pending the balance work. And it is submitted that the tendering process is nearing completion. So it is submitted that the work in question relates to infrastructure project of construction and maintenance of NH
NHIDCL.
37 from
Jorhat to Jhansi.
Jorhat to Jhansi. And we submitted that as the road conditions are not good. Comma. It is required to be clarified that the order dated, the impugn order dated 3/10/2023 shall not be a bar for the applicants to close the, to complete the tendering process. Full stop. In this regard, the learned senior counsel for the respondent number 1 and 2 has submitted that the tendering process has not been stayed by the impugn order dated 3/10/2023. It is submitted that the respondent numbers 1 and 2 are only aggrieved by consequential actions that may be taken by the appellants against the respondent numbers 1 and 2. Respondent number 1. Accordingly, it is submitted that that as per instructions received by him, the respondent number 1 has no objection if the tendering process be continued. Next paragraph.
I have a small further prayer lordship. As because lordship is issuing notice, after the termination, there are certain rights accrued in favor of the employer. One is lordship, they can encase the bank guarantee, and the other one,
they can,
No, for that we'll have to,
yes,
we'll,
Lordship, only thing is that, and also to take over all the properties which they have already removed substantial amount. Now, only thing is status quo in that respect may be maintained. We are not going to encase the bank guarantee.
But there is no pleading about all this, my lord. Let
There is
that.
no pleading,
let-
but
Your
status quo as
your
on
lordship
today,
is issuing notice, let
because
us.
if,
file a-
for that,
they are doing illegal.
No, no, my
no,
lord,
that-
absolutely not. We are
no,
not
that may
doing
be there,
illegal
but let
thing.
us see what is your prayer in this IA.
See the operation of the impugned interim order.
And
we are
the
not going to
grounds
take
are
any-
mentioned in
but
the appeal, my lord.
however,
The
it is-
grounds are only that,
No, Mr. Saikia,
Lord.
for that you have to make a prayer.
absolutely.
On the next day you make a prayer, we'll consider that.
State the operation of the interim order. Now, we are not taking any action against him. But they are taking advantage of that.
No, no, my lord, that's a, my lord, I have to
No,
verify.
no, let him complete, let him
I'll have to
complete.
verify
No,
all
no,
these
let him complete
I-
this part.
What I am saying, if they are so.
Because if
fair, they are
both
so
of you
fair,
speak together, it will be very difficult to control the court.
certain rights accrue in terms of the contract agreement, that once the termination takes place, we can encase the bank guarantee. For that, they went within 2 days to the tribunal under section 9. Just to stop or preempt our move to encase it. We are not going to encase it, Lordship. We are not going to, neither we are taking anything from him in the meantime. But at the same time, what he is doing, the properties which belongs to us after the termination, that he is removing unauthorizedly. Or else, Lordship, we'll have to file a FIR. If that
You have to-
happens, we'll do that,
Yeah.
Lordship.
Them do that. Because there is no pleadings to this, so I have to verify.
That's why I want to play a fair game. That's the only thing, Lordship.
It's okay, but we can't traverse beyond what is being
No.
created.
Yes, there is a prayer, Lordship. In the main prayer, page 29. Roman 2. Page 29.
Well, this prayer with utmost respect cannot be entered in a section 37, my lord.
To return back all the plans which includes machinery in terms of the contract agreement and materials which were recorded at site by the district administration and authority engineer of the project as per clause 23.7 of the contract agreement. Why we are saying this? Because they have already removed it. So that to preempt that they further take over the plants and machinery which are still lying.
What we can do is that this fixed on 30.
Lordship.
You say that this pendency will not be a bar for you to move the trial court with these prayers.
Yes. Lordship.
In fact, my lord, I don't know, my lord, respondent number 3A, your lordship can always strike it off also, because it is the authority's own engineer, has nothing to do in this 37. So your
So
lordship
my
can
prayer
strike
is
it
not-
off and.
not to strike.
No,
dispose
no,
it off.
that will have different connotations.
Absolutely, your lordship.
It will
As
have
a-
different
Also,
connotations.
given to us, we'll indicate that, Lordship. We'll do appropriate prayer before that.
And about the machinery, the appropriate pleadings comes, we get a right to rebut and then the courts can decide, no problem in that.
No, that's fine. Trial court is a better option
Absolutely, come with
than a
another-
appellate court.
Pleadings has to
That
come.
liberty may be
Very
given.
well. That-
We can observe it.
Well, the
First,
only thing
accordingly,
that,
it is clarified that that in view of the contents of the order 310/2023 passed by the learned additional district judge number 2, Kamrup Metro Guwahati in Miss R case number 55 of 2023, the court does not find there to be any bar for the appellants to carry on with the tendering process and as projected and in accordance with law. Next, the learned senior counsel for the appellant has pressed for an interim order in terms of prayer number 2 made in this appeal. Full stop. In connection with the said prayer, the learned counsel for the senior counsel for the respondent number 1 has submitted that an opportunity be granted to them to rebut the said prayer. Full stop. In connection with the said prayer made by the learned senior counsel for the appellants, the court is inclined to provide that the pendency of this appeal shall not be a bar for the appellants to move the additional district judge number 2, Kamrup Metro, Guwahati, with an appropriate application in terms of the said prayer.
On the next date.
Whenever you, I'm not saying anything.
Additionally, your lordship may also record the submission made by my lord and city of Fred that they are not going to encash the PG
No,
because,
no, no.
because why,
I'm not
why
saying
I'm
anything.
saying my lord, because
We are
now
already
that your
restrained.
lordship
That order
has-
not saying is not interfering.
but your lordship
And
has
already, no, no.
now since your lordship has kept this matter by lord issuing notice on the on 38, because that interim order is only till 38. Now, on that day, the lower court may not extend it because thinking this matter. is pending.
We'll clarify. No, we'll clarify
Clarify,
this.
right. Because that
So
is
the
only my-
pendency of this appeal, this appeal is only to examine the legality of the order dated 3/10/2023. And therefore, there shall be no impediment for the learned additional district judge number 2, Kamrup Metro, Guwahati, to
Extend.
to carry on with the proceedings of Miss arbitration case number 55 on 2023. And this pendency of the appeal shall not be operated, shall not mean that the further proceedings in the said case is stayed.
I know.
Or the impugn order, my lord, because your lordship is not staying the impugn order.
No, I'm not doing it.
That may be clarified. That is my anxiety, my lord, because on 38, if an extension is not given, then the PG will, they will.
I have not given a stay.
True, my lord, but your lordship have issued notice and your lordship have also.
That order
said-
is still.
You see, I'm making it very clear that I'm only examining the legality of 310.
Your lordship knows how your lordship's orders would ultimately be understood by.
No,
Because your
because you
lordship
see,
knows the
no, no.
practicality of the aspect. So
No,
only
no.
to that aspect, otherwise no problem. my
No,
lord.
no, otherwise I would not have allowed the trial court to proceed with the matter.
But
If
because your
lordship
lordship
passes
issued
that order, that
notice-
will amount to lordship is interfering with.
Just a minute, let me
Just
understand what Mr.
clarification.
Goswami is saying.
Because my anxiety is only that, to that extent, otherwise no, absolutely no difficulty. Since your
No,
lordship.
no,
has
I have
issued the
given two
notice,
clarifications in the order. Number one, it will not be operated as a stay, number one. and
that
the-
has come, my lord.
And that second is that the trial could proceed.
My lord, your lordship have said stay of the proceedings. Your lordship have said this order will not operate as a stay of the proceedings. Proceedings will go on. But if that interim order that has been passed on 3rd is not extended,
You
then I
see,
shall be in trouble.
you see,
Because their
No,
only
no, no,
problem.
Mr.
was that
Goswami,
it should not
if I stay the interim order,
No,
then,
not stay
no,
the
no,
interim order.
let us say we are staying the interim order, then what happens?
Then I am in trouble, my lord.
No. Then the trial court proceedings will not be carried on.
Will not cut.
So therefore, I'm not staying, it means that it is continuing.
My lord, in other way, the trial.
No,
court
no,
may
no.
think they will
That
continue
can't
with the
be, it can't be interpreted like that. Because if I injunction order, I'm staying it.
If lordship passes that on that day, it will be further extended, that will be
No,
interpreted.
I'm not saying, I'm not saying anything.
Otherwise, my concern is still 30th. The impugn order is still 30th. So the validity
I
of
leave
the
it to your lordship, my lord. If something happens, we'll come back to your lordships for a clarification. Because why I am anxious, my lord, your lordship in this matter, we had to move very fast. Because immediately they wanted to take out the 6 crore rupees, which was lying. That is the only purpose. Otherwise,
in my case, how can they
only
take
that,
relief?
my lord.
This is my case.
No, it is my case.
No, because
Today is
we
my-
don't find,
And I am not asking that, only for that clarification. I
we
leave it
don't
to your
find,
lordship. It's just the
we don't find that
practical.
this order would be read
Very
as
good,
if.
my lord. If any difficulty, then I won't be here. My friend probably will be here during the vacation. He'll move a application before the vacation point.
I don't think. We call an arbitrator, Mr. Mazumdar. Can the orders be meant that the interim order is not to be extended? I don't think so.
What is the apprehension?
No, the apprehension is that I am not on the next date. since I have allowed the proceedings to go on before the trial court,
On merit, lordship can use.
on the trial court.
Yeah.
I have I have said two things. Number one, the proceedings before the district judge will continue, additional district judge will continue. Number two, that this order would not be construed as if there's a stay in the proceeding. So it will proceed. His anxiety is that if I don't clarify that the interim order, he says that interim order may not be extended on the next date. But that is, the apprehension can't be there.
Mention like that.
From there.
Yes. Now, my
No,
problem is
is
that
it possible to think like that?
Here possibly it's not there.
No, for you, supposing you are and as Mr. Goswami, you are there.
I have to pray for extension before the court.
Before the court, you know.
That's where I'm saying,
That's why I will
on
appear-
that day, now the learned judge may think, now since the High Court is examining the legality of the order dated 3/9/2023, therefore, it would be prudent not to extend that interim order. Whereas in this court, the learned senior counsel has made a specific submission before your lordship that they are not going to encash the BG, they are not interested in that. All that they are interested is that the ongoing contract should go on and the work should be completed, which we said we have no problem because that is not my case. And now they are saying that certain plans are there, which they might be very well. You file an application, bring specific pleadings, the court will take a
Okay,
decision.
we'll say that.
Possibly what my learned friend is indicating is he, because he may have a.
No, it's okay. We'll clarify that. No,
My
we'll-
case is
we'll-
very clear. I made a submission that. we
No,
are
we'll
not
clarify,
increasing-
Mr. Saikia. We'll clarify that it is open for the trial court to deal with this interim prayer.
On merit.
On merit.
On merit.
There is.
My submission regarding BG is before this court. Or to
I
get that
understand that.
clarification.
I understand
Yes,
that.
lordship. Now that
Mr.
word has been
it
put
is-
in my mouth in a different perspective.
It is, no, that is the art of advocacy. It is clarified that the pendency of this appeal shall not preclude the court to pass appropriate orders on the pass appropriate order in this arbitration case number 55 of 2023 in accordance with law.
Accordingly, and now, as per the materials available, because I will file a counter now.
No, it's okay.
Yes, lordship.
Huh.
On merit,
In accordance with, on merit, in accordance with.
highly
law.
obliged. lordship.
Okay.
Deeply obliged.
I'll take a break and come back.
Respondent. Why and how they filed the mistake, filed the suit before the learned court below, while the application before while the proceeding before the circle of this, obviously it was pending and it or some order was to be passed. My lord, they have filed an additional affidavit in opposition, my lord. They are in their affidavit in opposition, my lord, they have not clarified when they have filed their suit before the learned court below, but they have just stated being offended during that proceeding, my lord, they have left the proceeding and accordingly they have filed a suit. But my lord, that part was not in their my lord, in the suit, my lord. And my lord, important thing is that we have filed an additional affidavit today. Today, my lord, with regarding my lord, permission from the deputy commissioner, Nalbari, my lord. And he has issued that permission, my lord, on the basis of the circle officer's report, my lord. The process comes to the page, it's a little bit, my lord, running page, my lord, 39. This is Alexa 10, my lord.
Yes.
Yes, my lord. Order, since the petition submitted by Diganta Hale, Secretary Manoranjan Kala Parishad Kopaya, also seen the report submitted by the Superintendent of Police Nalbari and the Circle Officer Pasim Nalbari Evidence Circle, permission is hereby accorded for holding annual theatre with effect from 2010-2023 to 22-10-2023 at Kopaya Higher Secondary School field under Belser PS. The concerned committee public organizers should abide by the following terms and conditions. Some terms and conditions were given, my lord, but the permission was accorded to us. It was, my lord, issued yesterday, my lord, on 16-10-2023. So we have brought that also, my lord, before your lordship. Now, my lord, our case is clear. The circle officer has given the permission, accordingly the deputy commissioner has also given the permission, and we took NOC from the concerned high school, high secondary school, and accordingly, my lord, we have moved the theatre party, and thereafter, my lord, affidavits, my lord, in order. They are just making out the case. And in their affidavit, my lord, they have annexed two documents, my lord. Annexure 2 and 3, my lord. In their running case, my lord. Annexure 2 is running case, my lord, 48. 48, my lord, this is a complaint filed by the Gaon Pradhan. So Gaon Pradhan is anyhow, not anyhow, my lord, involved here, my lord, and not a party here. They are filing this complaint filed by the Gaon Pradhan. This is Gaon Pradhan's complaint, but this is totally, my lord, one-sided, my lord. He is just preparing them. And the other document, my lord, this is very surprising. Annexure 3, my lord, page 50. This is an NOC issued by the school, and this is regarding my lord holding some cinema party, my lord. They have no objection regarding anybody. Only they have the objection if we go there. And and my lord, they are not anyhow affected because we are holding on 20, 21 and 22. And they are so is on my lord 23 to 25, my lord. They are not anyhow affected. And in their visa, my lord, visa case, my lord, they have in their CIDL, my lord, they have shown the property as 100 square meters. 100 square meter is very less, my lord, it's measuring. 100 square meter is not at all possible even to them also. It is 10,000 square meter approximately.
10,000 square meter.
Yes, my lord. 100 meter from, my lord, all the side, my lord. They are showing as 100 square meter. If it is 100 square meter, that is only 10 meter, 10 meter. 10 meter, 10 meter, my lord, how they can, my lord,
Where you're showing from where? Where is the pleading?
they are, my lord, what they have, my lord, submitted before lordship, my lord, visa case, my lord. They are CIDL, my lord. They are CIDL, my lord.
100 square meter.
100 square meter. The Popeye High Secondary School fill a plot of measuring land measuring 100 square meter. 100 square meter is not possible to them. They are stating all this so that we can be part. And the Puja committee has no objection, my lord. They have also issued the no objection, my lord, to us.
Okay, yes, what do you have to say?
My lord, the dispute is regarding the right to use the higher secondary field, my lord, Kakaya Higher Secondary Field to convene a mobile theater, my lord. And before submitting, my lord, I would like to take your lordship to some documents, my lord, which they have not filed. First, my lord, at page 15, my lord, of their petition, my lord, page 15. They have page 15 is the translated copy of the relevant portion of the resolution dated 8/9/2018. So this says that the meeting has decided not to allow any other theater party except the theater party invited by the Surabhi Sangha during Durga Puja. This is the respondent, my lord. And this resolution was taken in the year 2018, my lord. Now, what we have submitted that 100 square meter, there may be some mistake in writing the measurement, but it is not disputed that two theaters are not possible in that field, Your Honor. Now, Your Honor, may kindly come to page number 4 of their petition. Page 4. The main petition, Your Honor. 6 lines from the top, my lord. The petitioner came to know recently that a resolution dated 8/9/2018 was issued in favor of the respondent by the President Secretary of SMDC, Kakaya High Secondary School, this such and such, and on that basis, the respondent is only entitled to convene any mobile theater in the said school playground,
The petitioner being also interested to convene a mobile theatre in the greater interest of the locality as well as the concerned institution, they represent, express their interest before the school management committee. But the committee informed that a resolution dated 8/9/2018 is there. The resolution which I have showed just now, you know. 18 is there and that is to be recalled before granting any permission in their favor. Accordingly, a general meeting was called for on 6/8/2023 to recall the previous resolution dated 8/9/2018. And the general meeting was held in the presence of a huge people at large. The previous resolution dated 8/9/2018 was recalled by a separate resolution dated 6/8/2023. Now, my lord, this right to use the field, this emanates from this resolution, my lord, of 2018. And they says that this resolution was revoked by the another resolution which was taken on 6/8/2023. And that resolution, my lord, you will find at page number 21, my lord. Page number 21. This is a type copy. Today on 6/8/23, the meeting is organized by the Manoranjan Kala Parishad under presidency of Gaon Panchayat President, and the following decisions were taken up. The majority of the people present have consented for convening the Hangul Theatre invited by Manoranjan Kala Parishad, that is the petitioner, at Kakaya High School playground. The meeting has opened to constitute a committee for distribution of place among the Manoranjan Halai, to Ravi Sangha for convening both the theatre and puja celebration as well as the place for business market. The Gaon Panchayat President Secretary will be also a part of that committee. Now, at page 22 is the vernacular. Your honor will see some Kamleshwar Nath has signed this resolution. There is no seal and signature, nothing, and there is no signature of any other members. And the earlier resolution, my lord may see at page 20. This resolution was signed by the President Secretary of SMDC, Kakaya High School. Now, and that resolution also contains the signature of almost 25 members. And it was a proper resolution taken. And the resolution upon which they are relying, that this resolution of 2018 was revoked. There is no seal signature who has signed it. Only one person, there is a signature of only one person. So without the signature of President and Secretary of the School Managing Committee, how the resolution of 2018 can be revoked? And that is why the court below, while passing the interim order, yes, it has clearly held that that resolution dated 2018 is still in force. And on the basis of that resolution, we have made out a prima facie case before the trial court. Now, and Your Honor, they have basically challenged this impugn order, saying that in the injunction petition, we have suppressed the fact that the circle officer has passed certain orders. That letter which they have relied, my lord, that is at page number 27. So they have said that we have suppressed this order and we have not, but if your lordship will see the date, and here I want to submit that we have filed the suit and the injunction petition on 11/10/2023. I have confirmed in from the e-court date of filing, my lord, 11/10/2023. And this letter was sent on 13th.
Which letter?
My lord,
Which letter?
27, page number 27. Here also they have made a wrong submission yesterday that this is an order of the circle officer. No, my lord. This is an internal letter sent by the circle officer to the deputy commissioner, laying down the facts, Your Honor.
and praying for consideration of the same and taking necessary intervention.
You filed this suit when?
10/11/2023.
No, 10, 11, 11 we have not seen.
11/10, sorry,
11/10, huh.
sorry. 11/10/2023. And this letter was sent by the circle officer to the deputy commissioner. It is an internal departmental letter, Your Honor. How we come to know about this? Yesterday only we came to know about this letter. And this is not any final order. It has only laid down the facts for consideration by the deputy commissioner. So they are challenging the UP order, saying that we have suppressed these facts. And here, one thing is very clear from this letter, Your Honor, this page 27. At point number 1, Your Honor, the facts which the circle officer has laid down. The Kakaya Higher Secondary School field is situated just adjacent to the premises where Kakaya Durga Puja is held. For last few years, one theatre was held in the premises of Kakaya HS under the banner of Surabhi Sangha Kakaya. That is the respondent. So since last several years, we are running the show in this school field. And the petitioner, Your Honor, will find at point number 3, the other theatre organized under the banner of Manoranjan Kala Parishad, that is this petitioner, was held in another field at Bhakuabanda in the last few years. So we have our own independent spaces. They have their own space.
Everybody has their own monopoly.
Oh, I know.
Okay,
So now, no,
yes, madam.
first completely complete. So now from Bhakuabanda, they have come to this place and now they want to organize this theatre in this school. Now they have submitted that they want to play the theatre on 2021.
It's okay. This is a case of animal instinct, Mr. Mazumdar. Every animal has a space. Huh? There's a territory. So once another of the same species jump into one territory, then there is a fight. Okay, I pass necessary orders. I'll examine this and pass.
One point, my lord. Just because they says that or they want to play the theatre on 2020 and 22, and we want to play the theatre on 23, 24, 25. So there should be no contradictions here. But Your Honor, if they will be allowed to play the theatre on 2020 and 22, we won't be able to do our play on 23, 24, 25. Why? Because it takes minimum 3 days to construct the entire setup here, and a minimum 1 day to dismantle it. So if they play their theatre on 20, 21 and 22, till 22 night they will be playing, and on 23 they will be dismantling it, and then we require another 3 days to set up our this. So that is why, otherwise.
You can't borrow the earlier pandal. You can't borrow that and do your theatre. No,
They won't give us, Your Honor.
they won't give you. Okay.
Because that is the practical difficulty. So
Okay, we'll consider and pass orders in the chambers.
Only 3 things, my lord. He submitted one thing is that the resolution which was RD resolution was recalled, my lord. He has submitted that only one person has signed. It is not, my lord. Actually, I have filed the case with urgency, my lord. That is why, my lord, other signatures are there, my lord. As due to lack of time, my lord, I have filed only one page, my lord. But the relevant person I have mentioned there. And the other part is that, my lord, he has.
No, but it's dangerous. When you withhold documents, it becomes dangerous.
Yes, they have neither filed.
Because his argument depends on that. We appreciate the documents on basis of what is available on record. If you say that we have withhold something, it is at your own peril.
And it's the first page. my
No,
lord.
I understand,
Yes.
but it is on your own peril. You have,
It is a public issue, my lord.
I
And
can't,
other parts, my lord. Other part, my lord, he has relied upon that circle officer's, my lord, permission. He is relying upon that particular document, but he is not relying upon the later part, my lord. Because he has said that he filed the case before the learned court bill on 11th, But according to the circle officer's permission, my lord, it was on 6th of October, my lord. Both the parties were called upon their to his office, and accordingly the hearing was there. So they were aware of the fact that matter was pending before the circle officer. Some order was to be passed, but suppressing that particular pendency, my lord, they have filed the case before the learned court below. And the last part, my lord, the learned court below, what the learned court below has urged, my lord, learned court below has granted us time. Granted us time, my lord. We filed a petition asking time, my lord, for filing written objection, my lord. But the learned court below has granted us time. And the subject matter of this case was that to restraining the defendant from peaceful position of their, my lord, the plaintiff's peaceful position during this period. For subject matter was, my lord, 2021 and 22. So while, my lord, we were allowed to file our written objection on that, fixing the date for 31/10/2000, my lord, this, my lord, after so is over. So, my lord, the learned court below has one hand, my lord, granted us time for filing written objection, but the other is, my lord, the learned court below has passed that order. That means the learned court below's order has been become infractious because of that court's itself order.
No, if you have watched the proceeding today, you will find that this is something which I also do. I issue a notice on the interim prayer and then grant that interim prayer. I've been doing not for a year. Since I've been elevated, I have been doing same thing.
And
When I'm granting, you see, trial court when grants injunction in a application, what does it do? It issues a show cause notice and grants an interim injunction.
but the problem is that, my lord, we were granted time for filing written
No,
objection,
that's okay.
and the subject matter was 2021 and
No,
22.
no, I also do the same thing. Today also you have seen in the interim applications when I am passing an order, what I'm doing. In FNC appeals, you have seen me passing orders. What am I doing? Because you see, I have a habit of when I am pointing out finger at you, three fingers are pointing at me. So I first introspect myself. What have I done? In every case, when I'm passing an injunction, I'm issuing a show cause notice and passing an order of injunction. If I'm staying something, I'm issuing a notice and then staying it. So what am I doing? Is right or wrong? That is the question I'm posing to myself, not to you.
My lord, my submission is that my granting time to me, my lord, it has become infractious because of the court's self order. And
No, that we don't know. You see,
and-
that is something
and
we will
if
not
the
comment.
court would have rejected our death minor petition, definitely we would have done remedy before other from my lord. But
That
the
we
court
won't
has not
comment.
rejected that. And last part is that this deputy commissioner has accorded my lord permission. Circle officer has accorded.
My lord,
Who are the
yes,
administration-
Don't interrupt when the others are doing.
Who are the, my lord, administration who are controlling the administration, they have no.
I'll take care of it.
Kindly
I'll take care. How do you
publish
take care of it?
any
Mr.
matter.
P.K. Das for the petitioner and Mr.
Committee.
D.K. Medi for respondent. Pass orders in chambers. It will be released tomorrow morning, not today. By the time I pass dictate the order and then get the printout, it will be more than closing hours. Orders will be released only tomorrow morning.
Timing item 59.
Just a moment. Okay, you got the judgment?
Minor.
Yes. That is the only query we have.
I'm staying here.
It's
My
okay, I have
address
seen
is
that.
given Evergaon.
I've seen that, but yesterday I did not have time to make a search.
Fine.
So I was just thinking if this is not produced, I'll dismiss it. If it is produced, I'll issue a notice. Okay, had Mr. But I think you'll have to argue something to justify your appearance
Yes.
or not required. Or not required.
Good sir. If the notice is there to save time, then
No, that's that's the art I've learned. There'll be say matter is being dismissed. The lawyer town will say, Lord should be dismissing the matter. Well, Lord should just record the presence.
yes, sir, I'll go with it. All is well that ends well.
That ends well, okay. Had Mr. D. Mazumdar, Senior Counsel, assisted by Mr. S. Deka, Counsel for the petitioner. Next paragraph. By filing this application under Article 227 of the Constitution of India, the petitioner has assailed the order dated
12/10/2023.
12/10/2023, passed by the learned civil judge within bracket senior division, bracket clause number 3, Kamrup Metro Guwahati in MISG case number 1036 of 2023. By the said order, the application filed by the petitioner under section 151 CPC for restraining the respondents from taking forceful possession of the land in question was rejected without issuance of notice. Next paragraph. The issue notice returnable. The issue notice including notice on the prayer for interim relief returnable in 4 weeks. The petitioner shall take steps for service of notice on the respondents by registered post with AD. Where is that order? Which page?
127.
120.
7.
Next paragraph. The learned senior counsel for the petition has prayed for interim relief. Full stop. It is the projected case of the petitioner that an ex parte judgment and decree dated 29/11/2022 was passed by the learned civil judge within bracket senior division number 3, Kamrup Metro Guwahati in TS number 384 of 2019. Full stop. Coming to know of the ex parte decree, the applicant, the petitioner has filed an application under Order 9 Rule 13 CPC, which was registered as MISJ case number 1035 of 2023 for setting aside the ex parte judgment and decree. Full stop. The petitioner apprehended that he may be evicted without due process of law. Where is your petition? Where is your prayer?
Page 113.
11
113.
113.
There is a page 123.
by evicting the petitioners forcefully and illegally. The Learned Senior Counsel for the petitioner has also submitted that the respondent number one has not prayed for recovery of possession of the suit premises, and therefore the basis on which the apprehension is expressed is submitted to be therefore it is submitted that the apprehension is based on the said fact. Next paragraph. The Learned Senior Counsel for the petitioner has also produced has also placed reliance on the decision of this court in the case of Ramesh Chandra Kalita versus Mira MIRA, Patwari PATWARI and others, comma, within bracket 1997, bracket close 1 GLR 287, project that in a given situation, comma, the court has the power under section 151 CPC for grant of relief in case if justice demands it. Full stop. Having regard to the projection made by the Learned Senior Counsel for the petitioner that the respondent is not prayed for recovery of vacant and cast possession of the suit land. And that he apprehends, and that the petitioner apprehends that he may be evicted without due process of law. The court is inclined to grant
Page 22.
it is inclined to, but not to restrain the respondents from evicting the petitioner from the suit premises being land measuring 2 kata 17 measure covered by page 22 by so and so. Without following the due process of law. Next paragraph. The pendency of this application shall not be barred for the learned civil judge within bracket senior division bracket close number 3, Kamrup and Guwahati to proceed with the adjudication of Ms. J case number 1035 of 2023. Next, the petitioners shall produce a certified copy of the order before the learned trial court. Bring the order to the notice of the said learned court. You take this citation.
Item 16 of daily list.
Yes.
Table hello. Issue regarding the non-zero and zero party. And
Just a moment. 16. You are the plaintiff for the defendant? defendant.
They are the brother.
What is the substantial question of law you have framed?
Because the- It's too much.
Page 2. What is the evidence that was misinterpreted?
Did you our evidence only was can see. Paragraph 13, page 12.
12.
Yes. Page 12, paragraph 13. matter.
Yes.
This DW 2 and DW 3 have removed that they know both the plaintiff and the defendant of this suit. They also know the sweet land. They saw the Katsa house in the sweet land and the defendant was living in the sweet house and his father and the brother. They know that the sweet land was passed by the father of the defendant 30 years ago. From Govinda, India 1996. The elder brother of the defendant number 1 left for Delhi along with his family.
Just a moment, just a moment. The suit land was purchased by the father of the defendants 30 years ago. What is the name of your father?
Kabar Dev,
Pardon me?
Kabar Dev, Dev, Kabar Dev. Paikasa Dev. Paikasa. But subsequently, the plaintiff, in collision with the real owner, he got registered.
Where is your written statement?
And he can be taken by Lord Providence. Okay, madam.
40.
Paragraph 5, I have taken in play. Then the non-gender and making a party. My elder brother who passes, he has not.
Non-gender in second appeal, you will not be succeeding unless you show what was the who is the necessary party. Merely by making a statement in the written statement, have you adduced evidence that who is the necessary party?
I said that my elder brother, they also said the elder brother also passes the land along with the plaintiff. Adjacent land, but that elder brother has not been passed.
But why is that? Why is their presence required?
Because one of the land is same compound. He say plaintiff said that.
No. Eviction by a co-owner is permissible. That is well settled.
This is the only point. Otherwise, one of the other evidence says that father also purchased the land. 1990.
In your written statement, where is the stand? On which date you had a displayed adverse position?
Yes, okay.
It is only in page 3 you write 12 years. But 12 years from where? The position must be hostile. You have a copy of your exhibits?
Not there, but evidence, but
This document you are showing us is the sale deed of the plaintiff.
He said they've purchased us.
They have purchased the land.
They later on. Later, later on, the plaintiff in collaboration with the real owner, he got this treatment. Originally, my father has purchased the land by custody.
No, for that you don't have any document. There's no document to prove that. Your earlier purchase,
Electricity bill.
those do not determine title. They do not determine title. Because in my bungalow, I'm residing in an official bungalow where the electricity bill is paid by me. Doesn't make me owner of that premises. It's a property belonging to the High Court.
Otherwise, not. Because they pass by registered deed. Only fact is that some witnesses says that, but originally our father passes that land. By registered deed was not there. Subsequently.
Registered deed is not there.
But
Password is in the, and password is at 2.
I have some different, I will.
Okay.
Find 3 cases over, 2 miscellaneous cases in the arbitration agreement. One is for combination and dealer and another is for the virtual state. And the matter is in execution states in the lower court. So I need a matter be taken before writing on the court.
That will be court master. Mr. J. Ahmed, counsel for the appellant. Now I present call for the respondent. Appellants. Next one. Agreed by the first appellate judgment and decree. dated 24/1/2019, passed by the learned civil judge Shiv Sagar in title appeal number 6 of 2017, by which the judgment of degree dated 9/3/2017, passed by the learned Munsif Soraido Sonari in TS number 4 of 2009. Decreeing the suit was affirmed. Full stop. The appellant is the appellants are the defendants in the suit. Next paragraph. In brief, the case of the respondent plaintiffs, respondents dash plaintiffs. Singular respondent plaintiff is that he is the owner of the suit and described in the plaint by virtue of registered sale deed dated 3/1/1997, over which a house was constructed in the year 1998. And since then, he and his family were residing on it, in it. Full stop. It was projected that in the month of September 2001, the respondent had to go to Delhi, and accordingly he requested his brother, the appellant, number 1, who was residing in the rented house at that time, to look after his mother. Full stop. Taking advantage of the absence of the respondent, the appellants had trespassed into the suit premises and started to reside there from the month of October 2001. Full stop. The respondent returned from Delhi in the month of November 2001. And as the appellants did not vacate the suit premises, the suit was filed for eviction after serving advocate's notice dated 23/4/2008. Full stop. Next paragraph. The appellants, by filing the written statement, denied the allegations and it was stated that the suit land was purchased by the deceased father in the year 1993 by executing a Kacha agreement with the real owner, and the house was constructed by their father. Though it was admitted that it was stated that the deceased father had allowed the respondent and the appellant number 1 to reside in the said house. But in the year 1996, the respondent had left for Delhi with his family. And then the applicant number one was paying municipal taxes in the name of Radhisha Mishra since Radhisha Mishra, within bracket, respondent since 1996. It was claimed that as the applicant, as the applicants had been staying in the suit premises for last 12 years, their position was adverse against the real owner. And accordingly, prayer was made to dismiss the plaint. The following issues were framed for trial by the learned the following issues were framed for trial. Right here. Page 21. Next paragraph. Same as paragraph 5. Page 21. Five and paragraph 7 and page 22. Same. Next paragraph. The issue numbers 1, 2, and 3 were decided in favor of the respondent by holding that there was cause of action for the suit. The suit was maintainable and that the suit was not barred by limitation. In respect of issue number 4, another trial court relied on Exhibit 1 being the registered sale deed dated 3/1/1997. As well as the admission made by the appellants that the respondent was the real owner. It was held that the ownership of the respondent over the suit land on the basis of sale deed was established. And therefore it was held that the respondent was having ownership over the suit land and had right, title, and interest over the suit land. In respect of issue number 5, comment was held that although the defense was taken that the suit land was purchased by the father of the appellants, but as no relief was sought for against the real owner when they had come to know that the suit land was sold to the respondent, it was held that the respondents had waived their right by remaining silent even after knowing that their right over the suit land was at stake. So accordingly, it was held that the appellants did not have lawful occupation over the suit property. And the plea of having rightful possession over the suit property was found to be not maintainable. Hence, it was held that the respondent was the bona fide purchaser of the suit property. So accordingly, in respect of issue number 6, as battle was declared in favor of the as the respondent could establish that he had purchased the suit land from the real owner, the trial court held that the respondent was entitled to a decree for eviction of the appellants on the strength of registered sale dated 3/1/1997. Accordingly, the sale deed was found to be valid. Sale deed 3/1/1997 was found to be valid, and the respondent was found entitled to the decree of khas possession of the suit land by evicting the appellants therefrom. First of the suit was decreed with cost. First of the appellants filed a first appeal before the learned first appellate court, which was registered as Title Appeal number 6 of 2017. And the learned first appellate court had formulated the following point of determination as to whether the judgment and decree passed by the learned trial court is justified and proper or needs any interference in this appeal, in the appeal. First off, with a brief discussion of the pleadings and evidence, all the issues as decided by the trial court was affirmed. it was suffice to mention that the learned first appellate court, on examining the materials available on record, had found that the appellants were taking two plea. Firstly, that the appellant appellants were claiming that their father had purchased the suit land and allowed the appellant number one to live in the suit land. And secondly, that the appellant number one was claiming that he had acquired adverse title against the deed owner. First, they said plea was found not trustworthy. As it was not needed by the appellants about the date on which the appellant number one had come into possession of the suit premises. So the learned first appellate court also found that the appellant number one had not deposed in his evidence that he had possessed the suit land open and undisturbed or adverse against the respondent. Accordingly, it was held that the respondent had been able to prove his right title interest over the suit land, and being the purchaser of the suit land, it was found that the respondent had a right to the appellants. Accordingly, the appeal was dismissed. First off. The learned counsel for the appellant had submitted that the judgment and decree passed by both the courts below were perverse and bad in law. And that the evidence of the witnesses were misinterpreted, both in facts and in law. So it was also submitted that the both the courts had erred in on facts and in law by holding that they had failed to establish the rights of adverse possession. It was submitted that a specific plea was taken that the suit was bad for non-joint of necessary party. As a necessary party, without whom, being the elder brother, being one of their brothers, without whom the suit could not have been adjudicated and decreed. Full stop. In respect of the first point raised by the Learned Counsel for the appellant, the court has examined the materials available on record. Full stop. The Learned Counsel for the appellant could not demonstrate as to which part of the finding recorded by the learned courts below were perverse on any ground, including misinterpretation or misreading of the evidence on record. Full stop. It could not be demonstrated that the Learned First Appellate Court had arrived at an incorrect finding that there was absence of pleadings of the date on which the position of the appellant became hostile and adverse to the interest of the respondent. Full stop. Although it was strenuously submitted that the appellants had been paying electricity bills, municipal tax bills, urban property tax, etc. But in the considered opinion of the court, mere payment of electricity bills, municipal tax bills, etc. by the appellants in the name of their elder brother Radhesham Mishra, RADHESHYAM, one word, Mishra MISHRA, would not confer title over this of the suit land in favor of the appellants on account of adverse position. First, it could not be demonstrated that the position of the appellants over the suit land was hostile and adverse to the interest of the respondent. First one. Therefore, the second and third point urged by the learned counsel for the appellant is also found to be devoid of any force. Full stop. Next paragraph. In respect of the submission made by the learned counsel for the appellants that the suit is bad for non-gender necessary parties, it is noted that there is no foundational pleading with regard to the person in whose absence the suit could not be adjudicated. Moreover, as the appellants had taken a plea of adverse position, they said plea was only against the respondent and none else. Under such circumstances, the court does not find that the trial of the suit was bad for non-gender necessary parties. Therefore, the court does not find that any substantial question of law is involved or arises for so not for necessitating admission of the appeal. Therefore, as the court does not find any substantial question of law involved in the present appeal, the appeal stands dismissed. Stands dismissed. Full stop. There shall be no orders to cost. They dismissed at the admission stage, admission in inverted commas, stage without issuance of notice on the respondent.
এটা F2 এ আছে
Oh,
তাৰপাছত মানে আপগ্ৰেড দুটা আছে এইকেইটা মানে
three. Yes, Mr. Alam, what is the objection in admission?
This was the replicate.
Heard Mr. L. K. Bora, and counsel for the appellant, as well as Mr. N. Alam, learned counsel for the respondent,
Number one, ma'am.
number one, caveator. So this. Mr. L. K. Bora, counsel for the appellant, and Mr. N. Alam, learned counsel for the respondent, caveator. Respondent number one, caveator. Next paragraph. This appeal under section 299 of the Succession Act 1925 against the judgment and decree dated 10/7/2023 passed by the Learned Additional District Judge number 5 within bracket FTC bracket close Kamrup Metro Guwahati in TS within bracket probate
Right, so this is additional decision number 3.
3 or 5?
3.
3. Here it is 5. Here it
Let
is
them type of-
oh, 3. Okay.
It was prepared
Yes.
later on. It was prepared later on.
Preparation is no matter. In TS within bracket probate, bracket close case number 7 of 2019. Just by the said judgment decree, probate was granted in favor of the respondent plaintiff as well as performer respondent number 4. Performer respondent number 4. Next, the appeal is admitted for hearing, call for the records. You should notice returnable in 4 weeks. The applicant should take steps within 2 days for service of notice on the respondent numbers. Respondent number 2 and perform respondent number 2 to 4 by registered post AD with AD. List after 4 weeks. Give it discharge. What? You're not filed any interview application. You have to file an interrogatory application for that. No. In appeal, we don't interpret the prayer. Appeal will be based only on the certificate. No. If you can show that the statements made therein are substantive, are supported by affidavit. Then we can,
Upgraded item 67.
But in a petition, confidential petition is pending against the civil division petition filed after a delay of 9 days. In the meantime, the plaintiff has proceeded the execution proceeding. And in the interrogatory application, I have submitted the order, it is available at page 10. The next date is fixed on.
Just a moment, just a moment. Yes, yes, therefore the Kavita.
Yes, madam. My lord,
Okay.
actually, Mr. Sattar was supposed to appear as deviated. However, my lord, he has gone out of station.
No, but if you have put the matter into execution, then we have to stay it.
Yes,
We'll state it till the next date of listing.
Yes.
Execution will be stayed.
my lord.
Why,
If a statement so is granted, my lord, our only contention is that the earlier amount may be deposited to the respondent. And that the.
where's the degree? I have not seen that. It's a tenancy, a
Yes.
tenancy suit.
Yes.
What is the amount, rent payable by you? Receivable by you? What is the
My
amount?
lord, It is a total amount of 10,800. The earlier amount was decreed to be 1,200 per month from the month of April 2014 to the month of December 2014.
April to December,
Yes,
only that much.
yes,
And this subsequent amount, what do you call this? Pending rent and future rent was not allowed.
no, man. So degree, they have, the degree, everything has been allowed. The pending amount is 98,000 and odd amount. Yes, and this was decreed in their favor. 98,000.
98,000. So that you deposit as a precondition for grant of stay, otherwise it will not be operative. Where is the judgment and decree?
Judgment and decree will also be filed at page 41, the appellate court judgment.
41.
Sorry, Madam, it should be 9,000.
9,800. But you take instructions and come tomorrow, because if we are granting a stay in execution, then you'll have to pay the monthly rent, even if it is not decreed. Your obligation to pay rent continues till the even in the appeal or in revision.
We are depositing it before the court. As per the act, my lord. We are depositing it before the court.
Where is the statement made? You may go outside, take instructions and come back. You may go outside, take instructions and come back. But if you are granting a stay, then your obligation to pay rent during the pendency of the appeal as well as this revision will invoke that jurisdiction, and Abdul Mateen Chaudhary will invoke that and come back with the instructions. Wait for some time.
68.
Yes. Just. Where is the award?
State petition. It's not numbered. With the motion.
5,16,000 with 18% interest from the date of award.
424%.
But how many days of delay you are having? 500 days. So first you satisfy us on the delay. If there is a 500 days delay in an arbitration matter, why we should condone it? Please speak loudly. I'm missing your voice.
And it took down from this HDFC Bank Limited.
Yes.
What happened here was things were on a fire court in 2018. So what happened thereafter? He was trying to get the insurance money, and
He was trying to get
his insurance claim.
insurance claim. Okay.
So
Then?
what happened, soon after the pandemic came, and so he was unable to pay his installment. So at that time, the bank initiated the arbitration proceeding against him. And all the arbitration proceeding took place during the pandemic period, Your Lordship. Kindly see, Your Lordship, the award was rendered in the month of January 2021. And as per the Supreme Court order, the period starting from February 2020 to 2022 March, they were condoned 2 years, Your Lordship, due to pandemic. So, award passed against him ex parte without giving any chance to hear him. After that, Your Lordship, what happened? His wife was the current
This award is of which date?
of the 9th of January 2021. Your Lordship.
9 January 21.
Yes, Your Lordship. And after that, Your Lordship, he had to face many other litigations and proceedings, claiming his insurance money, which was kept by the bank, then again going to cases against the bank in the consumer forum. It is running after all the while, Your Lordship.
No, but still, that is not a ground to condone to condone it.
Your Lordship, kindly see his condition, Your Lordship. She is just facing one problem, one of the another, Your Lordship.
It's all saying worries come in a what you call in wholesale.
Your Lordship, I will-
Bad days don't come alone. Bad days do not come alone. It comes with many accompaniments. But we can't help it.
Sir, Your Lordship, February, Your Lordship, and understand his inability. And thereafter, Your Lordship, he was to face, he had to run after the insurance company. And thereafter, what happened, the insurance company did not pay his claim amount. And then the bank, Indian Bank issued notice to him that if you do not, our OCC account will be closed and money will be availed from your wife who is a guarantor. So under compelling situation, he was to accept his a very meager amount from the insurance company. And that amount again was held by the bank, not released. So again, for that, he has to go to the consumer forum against the bank. So he is running after litigations and litigation from related offense, Your Lordship. And in between, he also tried to pursue the bank to give him some time so that he can pay his installment. And it's not that your lordship, he didn't try to pay the installments. He was a regular paying, your lordship. Only due to unavailable situation. The main issue, your lordship, I have stated several points how he, even after all those incidents, he tried to pay his money installments. There are some earlier instructions also, your lordship, where like situations like natural calamities, the installment periods have been extended. So by the same it cannot be extended to this type of situations. Your lordship.
As per the Supreme Court judgment, the extension of limitation was up to 22.
Yes, your lordship, will run from 1st of March 2020.
It run from 1st of March 22.
The irony of the fact is that your lordship, even the certified copy of the award has not been given sub to the petitioner, which is mandatory under the Arbitration Act.
I don't know, you look at your page 7, some readings there that you have received the copy of the award.
Yes, your lordship, only the Xerox copy, not the certified, your lordship. And for which your lordship, we have to again explain the fact before the registrar why we're unable to connect certificate. And even the agreement has not been given to him.
You see, the difficulty is that statements made in the memo of appeal, they are not supported by an affidavit. So that you have not received the copy, that is, you are not sworn. Have you made the statement in the stay application?
Our statement, and both in the, our stay petition as well as in the appeal, your lordship.
Where is the statement in your stay application? Or in the delay confirmation application, wherever you stated that?
In delay confirmation, your lordship, I think the statement has not been made, but in the stay.
Where is the copy of the award?
That is annexed in only, your lordship.
Where is that? Which page?
The 23, your lordship.
23. If you're not, you file, you will take it up tomorrow. You file an affidavit bringing on record that you have not been served with a.
Your Lordship, I'm ready. My statement, Your Lordship. I'm trying to find the statement.
There's a second aspect you'll have to consider. If you have instructions, it is okay. Otherwise, again, you can come back tomorrow. You see, this is an arbitration appeal where the appeal is against a money decree, almost is the recovery of money. So you'll be asked to deposit 50% of the award before the court as a precondition for stay. If you have instructions, you take it up. If that affidavit is not there, you bring it on record tomorrow.
Yeah, positive. I need notice can be entered or not. Since the execution proceeding is going on. Your Lordship.
No, execution, if I am to state, I have told you. The law is that we have to ask for a pre-deposit. And that is a mandatory requirement, where the Supreme Court has come down very heavily of granting stay without pre-deposit. And second is that your submission that this decree was not served on you, award was not served on you. It constitutes a good ground, but you have to bring it on record by affidavit.
Only the Xerox copy is not.
No, but bring it on affidavit. We can't accept statement which is not made on affidavit. If you want, we'll take it up tomorrow. Okay.
I have already incited it in one of my statements, but now I'm not finding it, Your Lordship. I will bring it to your notice, Your Lordship.
Tomorrow?
So,
Okay. On the prayer made by Ms. S. Sharma, counsel for the applicant. This matter tomorrow, 18. Bring that. That would be a ground to exercise jurisdiction.
67 on analysis of instruction.
Yes, 67.
I have the instruction that we have deposited the amount, the monthly rate for the entire year, since we have claimed that it's a yearly tenancy. The tenancy was a yearly, no?
You have been depositing. Okay, so this 9,800 you handed over to him. Okay. There's a delay of 9 days, you can condone it. Okay. But Mr. S. Biswas, counsel for the applicant, and Mr. G. Imtiaz, counsel for the respondents. If there is one or more respondents. You have one?
More than one, more than one, 2 months, 3.
Okay, but for the respondents. Applicants, opposite parties. Next, by this interlocutory application, which is filed under Section 5 of the Limitation Act. The applicant who is the tenant of the opposite parties has paid for condoning the delay of 9 days beyond the period of limitation in preferring this a connected revision, the connected revision. Full stop. It is. Next, the suit for eviction filed by the respondents was decreed, against which the applicants had preferred an appeal, which was also dismissed. Full stop. It is posited that although the judgment was passed on 18/8/2022, but the decree was prepared on, decree was signed on 1/9/2022, and only thereafter application for certificate copy was made. And in the process of collecting certificate copy and engaging the council to file this revision, and intermittent illness which was suffered by the applicant, or the delay had occurred. Next paragraph. Although the learned counsel for the respondent has opposed this, opposed the prayer for continuing on the delay, but considering the explanation rendered by the applicants, the same is accepted as good and sufficient cause which has prevented the applicant from filing the connected revision on time. So accordingly, the delay of 9 days is hereby condoned. The registry shall now register the connected revision and list the same. In the motion column. Next, next order in IA Civil 3173. By this Hudson, by this application under 41 rule. No, I think you'll have to alter your pair. This is 41 rule 5. You're dealing with a revision. 41 rule 5 we can't invoke.
There is no provision for appeal in the.
No, I understand.
There is no other provision left.
I understand it can be under any other provision, but 41 rule 5 we want a jurisdiction to invoke. In a revision, is there a bar to ask for a stay?
I understand. But the nature of the case of the PNC.
You already have a pair. This being an application under order 41 rule 5. And as this is in connection with the connected revision file under 115 CPC, the court would have no jurisdiction to entertain this application. Not being connected to an appeal, according to this interlocutory application stands closed. Now in you get it registered and bring it tomorrow. Court master will ask the registry to register it. Revision, if it comes tomorrow, we'll take it up and pass into orders. We're not passing right now. Section of code. Register code panel.
Yeah.
I close. Try to get it listed. Make a mention tomorrow morning.
Yes. I do.
You will please inform Mr. Indias.
Yes.
Daily list item 17.
Yes.
In this case, some of the appellants are expired actually, Lordship. some of the appellants have expired and we have not been able to get the details of legal heirs. We've been in contact, but some of them are very old people and they've not been steady. They've not been able to get all the details of the legal heirs. We pray for 4 weeks lordship to file the subjection between lordship.
You won't say anything on the prayer made by Mr.
J. Das.
J. Das, counsel for the appellant, matter stands adjourned today, list after ensuing vacation.
Item 18 to 22.
Regarding service and reports for cases ready for hearing, madam.
Service is complete. Okay. Ms. L. Sharma, counsel for the appellant, and Ms. P. Barwa, counsel for the respondent number. Number one, in all the respondent one are present, and it is submitted at the bar that the case is ready as regards service. Mr. As LCR is also available, come on, raise the matter for hearing in its in its turn.
18 to 22 গোটেইকেইটা for hearing.
You have checked it. Service report is complete.
Item 23.
But in this case, by the last motion, the LC was called. The LC was called for lordship, now the LC has arrived, the matter may be fixed for hearing.
LCS have come.
Yes,
Okay. Mr.
J. Das.
J. Das, counsel for the appellant, submits that the case is ready as regards service and the LCR is also received. Just according to this, the matter for hearing.
So can you date?
I'm not fixing it right now. It will come, this is a 2012 matter, it will again, otherwise come in the top of the list. Don't take adjournment then.
Twenty-four.
Yes,
On number 3 lordship. as the
we are
case
still in
was-
steps.
Was in very well lordship, so we cannot able to take steps for it.
Okay. On the prayer made by Ran, counsel for the, your name?
Ash.
Asha?
R Shaha.
R Saha, okay. I'm sorry. R Saha, counsel for the appellant. Time is granted till 18/10/2023 to take steps for service of notice on the respondent number P. Mr. The counsel for the appellant shall take steps, which adverse orders will follow. Okay.
25.
Yes,
But I can discuss the dependency of the
appellant has died.
So the appellant died, and then in fact, I have also filed petition for submission to the legal gas server, but the petition is not submitted by the state. Because they have informed that there is some mistake.
You filed an application.
Yes, file application. but,
Okay, Mr. B. Hussain, counsel for the appellant has submitted that the appellant has expired during the pendency of the appeal, and he has filed an application for substitution which has some defect. Mr. You please.
Madam, another submission, madam, I just, sorry, the respondent number 2 also died. Respondent
Okay,
number
no,
2
no,
also
we are in respondent number 1 first.
one-
Sir, the appellant, you have,
Appellant, sole appellant.
so for that you have taken steps, it is defective.
Yes, it's already taken.
It is defective.
Right. had submission. Now I am going to for install.
No, no, the application is defective or we have passed orders?
Convictions are defective. That is not said.
Okay, full stop. The land council undertakes to cure the defect within 2 days. Full stop. Next para. It is further submitted that the respondent number two has also expired.
Well,
And
I have to take a step who is timely.
okay, and full stop. In this regard, the place forum is granted time to take appropriate steps in the matter.
Right.
So accordingly, matter stands adjourned today, list after vacation.
26.
Yes,
Madam. Your soon response already expired, madam. I have taken instruction from several times to the madam department, madam. I have also received one instruction request, madam. They are unable to find out the legal errors, madam.
but that's
They are trying to, madam, find out. madam.
no, but you see, in this connected to MC appeal, have you stated the recovery?
Madam, yes. Madam.
You state the recovery,
2 lakhs already paid, madam.
Huh?
2 lakhs already they have taken,
you deposited 2 lakh
madam.
before this court.
Madam, in the earlier, madam. In the earlier, madam, as per madam, here order.
Before the tribunal,
No, here, madam.
you deposited
I
here.
appeal at the time of.
So there must be someone who has appeared in the matter.
Earlier, they have appeared, madam. Their names are in the some cause list, madam.
Okay, okay. Just adjourn the matter then,
Madam.
on the prayer made by Mr. B. Sharma, counsel for the appellant.
Lordship's order was also there, 3-21, madam.
No, just a moment. This applicant, not appellant. Matters is adjourned today to enable him to obtain instructions. List after vacation.
Item 27.
Lordship, the arbitrator, the conducting arbitrator, Mr. PC Borduzari, is having some personal difficulties to act as the arbitrator. So your Lordship kindly appoint the new arbitrator, Vishwajit Talukdar, for this matter. We have filed an IA.
No, where you are saying that he has recused himself from taking up arbitration? Page number, no, that is a statement. How, but how you are saying it? No, you see, unless you go to the arbitrator, produce him the order of this court, and then he recuses something else, you get an arbitrator appointed. And then you make a statement that he has recused himself from taking up arbitration. I have no personal knowledge whether the Mr. Bharpujari has refused to take up arbitrations. Yes, your statement would not be enough. You see, this court has appointed an arbitrator. It is your duty to take the order, go to him, and then he will say yes or no. You take instruction because we are not satisfied. And then you are swearing an affidavit, you are saying paragraph 4 is based on your knowledge. Again, you also say that partly it is from the record. Because I go with the pleadings, I am, when I'm reading with you, I am also reading the affidavit. We adjourn the matter, we take instructions. Miss B. Saha, the counsel for the applicant is present. First of all, on a court query on statement made in paragraph 4 of this interlocutory application. What was the basis of saying that the arbitrator appointed by the court had recused from taking up arbitration? The counsel for the applicant waits for some time to address the court this after vacation.
$28.
Yes.
On number 1 and 2. As we do not take steps because due to bereavement losses and the providers.
You are paying for some more time to take steps.
Yes. Because of the petition on this number 1.
Okay, on the prayer made by Ms. R. Saha, counsel for the applicant. Time is allowed to take steps for service of notices in a substituted manner. Full stop. The process shall be routed through the registry of the court. Full stop. The next date of appearance shall be given as shall be given in the notice as 15/12/2023. Full stop. Newspaper publication shall be made on or before 15/11/2023. Full stop. Upon the publication being made, an affidavit shall be filed with along with the original newspaper as well as the relevant photocopy thereof. List on 15/12/2023. Item 29. I have to raise, there's a reference. So, two items are raised.
Steps on the R6 and R7. Private owner, we have taken it, this time I will take it by Justice Service in Calcutta. Okay, this is in Calcutta.
On the prayer made by Mr. R. Goswami, counsel for the applicant. Come on, the applicant is permitted to serve notice on respondent number 6 and 7 by way of Dasti. So the process shall be routed through the registry of the court. The notice is made returnable on so and so. After 5 weeks, you will list.
Because there's a holiday examiner give the
Oh, okay, so after 6 weeks, give a date after 6 weeks. Upon service and affidavit of service shall be filed prior to the next listing. Is this item 30? I'll not be taking up any other matter.
As per office note dated 3/10/2023, answer notice has been received for file. Which is the notice?
1 to 5,
1 to 5.
all of them.
Yes. By register, we will be allowed to take steps to speak to.
No, you see, this 5 says incomplete address.
Therefore,
it is-
dusty service and we may be allowed to take. Dusty.
You make it by the C.
Yes.
On all of them. On the preliminary says that the counsel for the appellant is permitted to serve notice on the respondents by way of the C by routing the process to the registry of the court. So the date of the notice is made returnable on so and so, list accordingly, along with affidavit of service. You can file prior to the next date of listing. Yes, which one? 66, what is it for? 66, who is for the insurance? You should have requested him.
Then it's a lordship. In item number 73, my lord, listing order may continue.
Item,
Item number
just tell the court master.
item 47, my lord, is still vacated, it's not actually listed. They have to show tomorrow. they have to-
Not day after tomorrow.
Let it come after vacation. Date may be fixed. The date may be fixed after vacation.
Because then 7th of,
Huh?
7th of November.
7th of November.
Then
No, not Tuesday, we'll make it 6th.
Well-
If it is open, 6th is open. Oh, okay, this item number
47.
47. That's not even- that application, make it tomorrow. This is item number 66. 66 खाली दियो।
Item number is 67, বিশ্বাস আছে। Register কৰিব লাগিব।
হ্যাঁ?
কোনটো এই মাত্ৰ কোৱাটো নেকি?
এই বুলি ক'লে।
Pause at 66.
Address the court master. I don't have time.